Good afternoon, everyone. Thank you for joining us for the Medical Board of California Quarterly Board Meeting, Day 1. While this meeting is being conducted with participating board members and staff at the meeting location, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments for those who wish to speak will be heard for each agenda item from individuals attending in person and remotely. To be ready for remote public comment, we ask that you please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and an attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the View Additional Meeting Information link on the first page of the meeting agenda items for information on connecting to the media and accessing meeting materials. Thank you, President Lawson. You can now start the meeting.
Thank you, Sean. Good morning. I'd like to call this meeting of the Medical Board of California to order. It's 12:32 p.m. I guess it's not morning anymore, so good afternoon, everyone. I'd like to first ask all of the board members and everyone here in the room to please turn your mobile devices to silent. For those who are tuning in or watching the meeting here in person, you may notice that board members are using their laptops, phones, or other devices during the meeting. They are using these devices to access board meeting materials that are in electronic format. If you're a member of the media or you require assistance or information, please see Aaron Bone in the back. Aaron, please identify yourself. This is an official business meeting of the Medical Board of California, and disruptions of the board's business will not be tolerated. Government Code Section 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear the room if order cannot be restored by removing or muting the disruptive people. We have a designated time on the agenda for public comment on items not on the agenda, and we will also ask for public comment on all agenda items. The board welcomes public comments on any item on the agenda, and it's the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. As Sean mentioned, this meeting is also being streamed via WebEx. Individuals attending the meeting remotely via WebEx will have the opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating this WebEx event will activate the hand raising and Q&A features of WebEx and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment, but this time period may be reduced depending on the number of people who wish to speak so that more people may be heard. The host will audibly announce when 30 seconds remain to conclude the public comment. After the individual's time for public comment has lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. With respect to agenda item 2, public comments on items not on the agenda, the board has limited the total public comment period for individuals to 40 minutes. Therefore, after 40 minutes, further comments will not be accepted. During public comment on any other agenda item, 20 minutes will be allowed for the comment period. After 20 minutes, no further comments will be accepted. And again, each person is limited to 3 minutes per agenda item. I'd like to remind all speakers to please stay on topic and keep your comments to the allotted time or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we're planning to end today's meeting by approximately 5 p.m. So I've officially called the meeting to order. And Ms. Strother, if you could please call the roll.
Mr. Arkartov?
Here.
Dr. Ayala Rodriguez?
Here.
Ms. Chung?
I'm here.
Ms. Holmes?
Here.
Dr. Mahmood?
Yes.
Mr. Portillo?
Here.
Dr. Solis?
Here.
Dr. Thorpe? Dr. Tolbert?
Present.
Ms. Torres? Dr. Sai?
Here.
Mr. Watkins,
Present.
Dr. Yip,
Here.
Ms. Lawson.
Here. Thank you. A quorum is present. And I would again like to remind members that we'll be taking a roll call vote on all action items. Before we move on to agenda item 2, I just wanted to allow Dr. Mahmood a point of personal privilege to welcome us.
Thank you, Madam President. And I really want to personally welcome the whole board over here in this hospital where I have worked for about 25 years. Honestly, I might be a little biased, but this is one of the bestest place to work, to get treated, and to have the community help. I really appreciate Dr. Wafar Rashid, who is here, and if you can really stand up applauding you and thanking you for giving the opportunity for board to be here. And I spoke to Dr. Corman, our CEO earlier, and he's sending all the best regards. Again, from the bottom of my heart, thank you, Dr. Wafar Rashid. Thank you, the board, to giving this institution a priority and opportunity to hold all of you. And thank you so much.
Thank you, Dr. Mahmood. It's great for all of us to be here in Pasadena and to be able to, be in the places, for the people that we serve. So thank you for having us, Huntington Hospital as well. Moving on to agenda item 2, public comments on items not on the agenda. Before I ask for public comments, I would ask individuals making comments to not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. Such discussions would be considered ex parte communications, as they could provide information to the members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. In addition, the board would like the public to address the board as a whole and not individual members. Again, please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they'd like a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed and to avoid compromising both the speaker's goals and the board's mission. If you want to comment on an agenda item, please do wait until that agenda item. Comments at this time are only for items that are not on our agenda. Again, please limit your comments to 3 minutes or less. First, are there any comments from the public present in the hearing room? Please come forward.
Okay. Can everyone hear me? Hi, good afternoon. I'd just like to make a comment regarding the fact that it's been a whole year and the board has done absolutely nothing about the proposal that TJ made about letting the public know that doctors are under investigation. And that was supposed to be an agenda item, but it's been completely shelved. And I just like to point that out because I think it's a big disservice to the public. And obviously, when you can look up your contractor and find out if they're under investigation, it doesn't seem right that you can't look up your doctor and know the same thing. So I hope that you'll action that and put that on the agenda for the next meeting. Thank you.
Thank you. Are there any other public commenters in the room? All right, seeing none. Sean, let's go to WebEx.
Thank you. If you'd like to make a public comment online, you can do so by raising your hand or just type anything into that Q&A window and we'll call on you by name here. First up here, we have Susanna Zarisky. Should be receiving that prompt now.
Hi, can you hear me?
Yes, we can. Please go ahead.
Okay, good. Hi, my name is Susanna Zarisky. I'm the citizen sponsor of Assembly Bill 3119. I'm going to start with a poem. Scholars say we have a constitutional crisis at the federal level, but there's a democratic crisis at the unelected California Medical Board level. For medical education, the board is slamming the brake pedal. On Assembly Bill 3119, both political parties agreed long COVID patients are in need. The bill adds a post-infectious disease class for continuing practitioners to pass to reduce long wait times in the long COVID clinic lines. Long after the pandemic, people have brain fog, fatigue, lung problems, and are bedbound. But the board ignores the desperate and sick. The board members are acting like kings, even though the country protests against kings. You're no royal if to public health you are not loyal. Overriding Newsom and every legislator, you're subverting democracy at its core. Do the monarchs decide behind closed doors? If the spaghetti sticks to the ceiling, the bill is approved, but if the spaghetti drops, the bill is doomed. Taxifornia is the 4th largest economy in the world. We pay high taxes for the board to follow the people's word. My 5th time asking for AB 3119 to be on the legislative docket. Kings, quit the board and stop taking money from taxpayers' pockets. Here's an explanation. When I had long COVID, I struggled to find a doctor to treat me because there's a severe shortage of medical providers who are trained in post-infectious disease care and specifically for long COVID, a disease that afflicts 1/5 of the people who get COVID. My then Assembly member, Evan Lowe, and I determined that the legislature needed to pass his bill, AB 3119, a bill to encourage medical licensing boards to add a class on post-infectious diseases and long COVID to their continuing medical education program for doctors to renew their medical licenses. With more doctors trained in the disease, there'd be less of a shortage. Evan Lowe sponsored AB 3119, and it passed unanimously in both the Assembly and Senate, and the governor signed it in September 2024. However, this board has refused to publicly discuss the bill since September 2024 during all of your quarterly meetings, while people with long COVID are still suffering from the long wait times to see doctors. I have asked Governor Newsom, Secretary Tamiko Moss, and the Director of Legislative Affairs at the Business Consumer Services and Housing Agency, and as well as Senator Josh Becker, to investigate the medical board's contempt for the democratic process and long COVID medical education. I've written to this board many times about this bill. You know how to find me. Thank you.
Thank you very much for your public comment. Next here, we have Marion Hollingsworth. You should be receiving that prompt. Try it one more time here, Mary.
Okay, can you hear me?
Here we go. Please go
Okay.
ahead.
Okay, thank you. My name is Marion Hollingsworth, Patient Safety Advocate. I would like to ask you to have a future agenda item that deals with how you plan to get doctor information to consumers, to improve it, so to speak. The system you use currently, even social media, is not up to date. For example, on Twitter or X, and on Facebook, you are now posting about doctor disciplines from December of 2025, 2 months ago. So basically you are 2 months behind, and even some of the tweets in Spanish still take consumers to profile pages in English with English documents. Mr. Varghese had mentioned at a previous meeting that consumers should go on the board's Excel page to get the latest doctor disciplinary actions, but that is not easily available on the board's website. There's no site that says this is where you look for it. You have to search for it and know the vocabulary of the board to know what you're even looking for. I've even had reporters ask me how to find disciplinary lists, and those are people who know how to dig for information. Even people I know who are like a computer professor asked me how to walk her through your website, and she knew how to deal with computers. Even if your emailed lists of disciplinary actions are inconsistent. You used to have 1 or 2 like every week, and now they are sent out randomly, usually with just a few doctors at a time, often weeks after the discipline or accusation is posted. And not everyone has an iPhone for your app, so that doesn't help. I know you expect consumers to check their doctor's profiles before every appointment, but that's not reasonable for busy adults, especially for parents with multiple children. I hope you can find a way to keep consumers informed and make the information easily available on your website. Please address this issue at a future meeting. Thank you.
Thank you very much for your public comment. Next here we have Rob Gordon. Rob, you should be receiving that prompt.
Hey, Sean, are you able to hear me?
We can, Rob. Please go ahead.
Yeah, couple things real quick. First of all, if I'm censored or blocked, you can find me at the website abolishmbc.org. I'm an opponent of the Medical Board of California. So once again, that's abolishmbc.org. To try to keep my sanity, I'm going to be live tweeting this. If you want to come and say hi, my Twitter handle is RobGordon001. RobGordon001. And I want to run on real quickly to something I say at every meeting, and you need to take it seriously. The intake form you have is entrapping people without providing enough information. People need to know that the second you fill out that form, the complaint form, you're giving up all your rights. You're certainly giving up your legal rights. People don't know that. You need to have informed consent. I'm fully aware that that's not really a thing, but you need to try to have that. Next thing I want you to know, I'm going to be sending out a full legal disclaimer. We'll also be going to the Attorney General of California. I've been keeping them posted on what I'm doing. I just need them to know about it. I want to at least leave a paper trail because I know how eager you guys are to take some metaphor or say something I wrote between the lines means that I'm planning a mass murder attack in San Diego. You've done it before, so don't think that's weird. I will post exactly what you shared, several things, but I'll post a few of them. What you shared with the people who did a workplace restraining order from a psychiatrist I never met who claims he's my psychiatrist. I won't go into that now. Quickly again, I want to run out to 3 policy things I'm going to be sending out to you, probably to your web address. One of them, and you're either going to like this or you're going to hate it. But as a professional project manager, I'm not in, one of the official status professions, but your job has been incorrectly scoped and you should be paid. It's outrageous that you are not being paid for your work. It's insulting to us. It's wrong for at least a dozen different reasons, but you need to get the legislature to pay you. You need to get money one way or another. Dr. Thorpe talked about having to read a 1,000-page briefing before he went to one of his, people he had to judge, physicians he had to judge. That's you can't do free work. It's insulting to us. It screws up the system in 100 different ways. So have a heads up for that one. I am also going to be sending a policy statement, personal policy statement, that I believe in individual responsibility and accountability. Your entire system is designed to refute that. The board starts by saying we're supposed to address the board as a whole. Let me tell you what I think about that. Individually, you people are all accomplished. Every one of you is smarter than me. When you get together in a group called the Medical Board of California, you instantly become stupid. Your IQ drops by 50 points. And so if I'm calling things that sound general, I'm referring to the board.
Mr. Gordon, please conclude. Your time is up.
Go ahead.
Thank you for your public comment. Next here we have Renee Alvarado. Renee, you should be receiving that prompt.
Hi, good afternoon. Can you hear me?
Yes, we can.
Beautiful. Hi, my name is Renee Alvarado, and I'd like to raise an important concern regarding the protection of physicians' reputations and professional integrity during the complaint and investigative process. Now, while I fully support transparency, accountability, and the vital role of oversight in maintaining public trust, I believe there should be meaningful safeguards to prevent physicians from being publicly shamed, mischaracterized, or unfairly harmed before complaints have been thoroughly investigated and resolved. A complaint alone does not constitute wrongdoing, yet in today's environment, the mere existence or disclosure of allegations, especially when incomplete or unverified, can cause significant and sometimes irreversible damage to a physician's professional reputation, patient relationships, and mental well-being, such as major newspapers or media outlets that are publishing unresolved cases. Even when a physician is ultimately cleared, the reputational harm may persist long after the investigation concludes. Now, due process is a foundational principle of fairness. Physicians deserve a process that balances public protection with reasonable confidentiality and protection from premature public exposure or misinterpretation of allegations that have not been substantiated. Now, all of that being said, I would respectfully ask the board to clarify what measures are currently in place to ensure physicians are not publicly stigmatized prior to the conclusion of an investigation. How does the board safeguard against misinformation, misrepresentation, or premature disclosures of unresolved complaints? Are there opportunities to strengthen policies that protect patient safety and professional dignity of physicians during this process? My intention here it's just to raise the issue, to not limit accountability, but to advocate for a system that preserves fairness, integrity, and trust, both for the public and for the physicians who serve them. Thank you for your consideration.
Thank you for your public comments. Next, we have Eric Andrist. Eric, you should be receiving that prompt.
Hi, everyone. It's Eric Andrist. I just wanted to call in real. I wasn't going to say anything, but I want to respond to that last guy who called in. Doctors are such whiny heinies. Oh my God, please. If a movie star gets caught being drunk and gets in a terrible accident and kills people, it's all over the news within minutes. But these doctors want us to not be able to check on them and see if they've had drug addiction problems or killed a patient or something. They have to go through an investigative process first. I don't think so. Come on, grow up, get some balls. We need to be protected from bad doctors. We turn to the Medical Board of California for that protection, but they are failing us. They're taking in over 11,000 complaints a year and only disciplining less than 4% of them. So we need a way to be able to make a judgment when we're going to a new doctor to see if we can trust even going to that doctor. We don't need to wait for an investigation for that to happen first, regardless of what the CMA wants to tell people, because they're the doctors' union. That's why Christine is so hot on them and follows them so readily. We need protection. The board is not protecting us. Don't take away these little tiny things that help protect us, like being able to see if a doctor's being investigated. We need that information before we go to a doctor and put our life and our health in their hands. Thank you.
Thank you for your public comment. Do a double check here. This time I don't see any additional requests in queue.
Thanks, John. I'll just go back to the room and see if anyone who's arrived more recently is interested in doing public comment on items not on the agenda. All right, I think that concludes agenda item 2, public comment on items not on the agenda. We will move on to agenda item 3, approval of the minutes from the last board meeting. Just a reminder that the minutes included in your packet are a brief summary and a record of our votes, but the full recorded meeting is posted on the board's website. Members, are there any corrections to the December 4th and 5th, 2025 board meeting minutes? May I have a motion?
I move to approve.
I have Dr. Sai moving to approve with a second from Dr. Mahmood. Are there any public comments from those in the hearing room? Sean, are there any public comments online?
Yes, if you'd like to make a public comment on agenda item number 3, please do so by raising your hand or typing in anything in that Q&A window. Give you a few seconds to see if anyone queues up. Not seeing any requests at this time.
Thanks, Sean. We'll bring that back to the board. Any further discussion or comments on the minutes? All right, Ms. Struther, if you could please perform the roll call vote.
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez.
Yes.
Ms. Holmes. Yes. Ms. Chung. Sorry.
Yes.
Dr. Mahmood,
Yes.
Mr. Portillo,
Abstain.
Dr. Solis,
Yes.
Dr. Thorpe, Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sai,
Yes.
Mr. Watkins, Dr. Yip,
Yes.
Ms. Lawson.
Yes. All right, that motion carries and the December 4th and 5th, 2025 board meeting minutes are approved. Moving on to agenda item 4, President's Report, including notable accomplishments and priorities, introduction of new board members, and communications with interested parties. I first want to thank our former colleague Jody Remke for her service. And I would like to welcome our newest board members to the Medical Board of California. I'd like to welcome Claire Holmes, who was appointed by the Speaker of the Assembly. Claire is a retired communications and public affairs executive with more than 25 years of service to healthcare and higher education organizations. Claire, we're delighted to have you join us. And I would also like to welcome Luis Portillo to the board. He was appointed by the governor last month, and Luis serves as the president and CEO of the San Gabriel Valley Economic Partnership, which is a regional organization, regional economic development organization right nearby where our meeting is currently being held. That's dedicated to strengthening economic vitality, opportunity, and community well-being in the San Gabriel Valley. So, Luis, welcome to the board as well. We're delighted to have you. I'd like to invite both of you to say a few words if you'd like. That's up to you.
Thank you. It's great to be here. I look forward to being part of the board, and it's an honor to serve.
Thanks, Claire. Luis?
Thank you as well. I'm looking forward to serving on the board and seeing, helping in any way I can. It's an important organization and look forward to it.
Thank you very much. We're glad to have you here, and it's really nice to have a very full complement of board members. I think we may only have one remaining vacancy to fill, so that's quite a change from the last couple of years where we've had a number of vacancies and had a hard time or spend a lot of time worrying about achieving a quorum. So it's nice not to have to worry about that today. Regarding communications with interested parties, I really don't have any specific interested party communications to report. I continue to receive on behalf of the board, a fair amount of inbound communication, all of which I pass along to our staff for an official or formal response, but I have not spent any time meeting offline. Feels like our meeting just happened. It was in December, so it's only been a couple of months, but I haven't had any specific meetings or contacts with interested parties beyond that inbound communication. Do any other members, this is the time to report if you've had any interested party communications as well. Dr. Mahmood, it looks like you do.
Yeah, a few people reached out to me for new legislation, and I think some will be discussed today
Great,
from the assemblies.
Great, thank you. Mr. Watkins, it looks like you've got something.
Yes, I continue to talk to the patient advocates and NBC and some of the other stakeholders.
Thank you. Any other interested party communications to report? All right. Do any members of the board have questions or comments on the president's report? Seeing none, we will ask for public comments from those in the hearing room. Is there anyone wishing to make a public comment? All right. Seeing none, any public comments on WebEx, Sean?
Yes, if you'd like to make a public comment on agenda item 4, please do so by raising your hand or type anything into that Q&A box. Give you a few seconds to queue up. Not seeing any requests at this time.
Okay, great. Thanks, Sean. We'll bring it back to the board. We'll move on to agenda item 5, which is a presentation on a regulator's perspective on artificial intelligence in healthcare. Please join me in welcoming Frank Myers. Mr. Myers is an attorney and is the Director of Regulatory Innovation and Member Services at the Federation of State Medical Boards, where, among other things, he oversees initiatives on regulatory advancement and digital transformation. Mr. Myers has been at the forefront of exploring how AI can improve oversight while maintaining fairness and accountability, and he frequently speaks on these topics nationwide. We very much appreciate you joining us again today to discuss AI in healthcare. Welcome.
Thank you. Can everybody hear me okay?
You can.
There we go. Oh, well, let's turn that video off because nobody wants to see my dirty back of my virtual background. Apologies, 1 second. I don't use WebEx a whole lot, and I thought I had my background loaded, so I apologize. Let's see, here we go. Perfect. There we go. All right, good afternoon, everyone. As already stated, my name is Frank Myers. I'm the Director of Regulatory Innovation and Member Services at the Federation of State Medical Boards. Thank you for having me back here today. I was honored to present to this board, I believe back in August of 2024 on navigating the AI frontier, and a lot has changed since then. Today, I want to build on that conversation with a more focused look at where AI stands right now in healthcare, how the regulatory landscape has evolved, especially here in California, and a couple of case studies I think you'll find directly relevant to the work that you do here at the board. And as always in these presentations now, I like to give these disclosures. This presentation was assisted by AI, and I'll be transparent about that throughout. Standard disclosures, again, this presentation is for informational purposes only. It's not intended to provide legal or medical advice. The views and opinions expressed are those of the presenter. And actually, I should probably share my screen, shouldn't I? There we go. Does that come through?
Yes.
I can see it, Mr. Mayor.
Perfect. Thank you so much. Okay, again, this presentation for informational purposes only. It's not intended to provide legal or medical advice. The views and opinions expressed are those of myself, the presenter, and do not necessarily reflect the official policy or position of any organization. Again, portions of this presentation, including the generation of images, were assisted by the use of artificial intelligence. As I go through this presentation, I may highlight a few other policies. And if I do reference a policy, I would always encourage everyone to go and read those direct policies and really absorb that information yourself. So a little bit about the Federation. If you may not be familiar, we are a national nonprofit that we represent the 71 state medical boards and osteopathic regulatory boards across the United States and its territories. Our mission is to support our medical member boards in their role of protecting the public. We do that through policy development, data services like the Federation Credentials Verification Service, advocacy, and increasingly through technology innovation. California, of course, is one of the largest and most influential medical boards in this country. So today's learning objectives are pretty much fourfold. Here's what we're really going to try and cover. First, the AI landscape in healthcare, just a high-level overview. Second, the U.S. regulatory response, or quite honestly, the lack of comprehensive federal response, and what states are doing in response to that, like California. And third, a deep dive into a recent pilot from Doctronic in Utah that I think has a lot of lessons that state medical boards probably should be aware of, or at least have an idea of what's going on. And then lastly, the work that we've been doing at the Federation through our Office of AI Innovation and how we've been researching and developing AI-powered tools for enhancing board operations. Before we go on to that, I would love to just see from a raise of the hands, who has used an AI tool like ChatGPT, Claude, or Gemini? And if you keep your hand up, if you still use it regularly? And who has used it in a professional or clinical context? So there's no right or wrong answers. This is really just trying to understand where we all are collectively in our AI use. This is really just a temperature check. If you were here in August 2024, I asked a lot of these questions, and I think a very few people were raising their hands and using tools like ChatGPT, and now we have Claude, Gemini, Perplexity, and many others that come out daily. And those aren't even touching upon the healthcare-focused AI that we're seeing come out on a weekly, monthly basis. So as I mentioned, we're going to start with AI landscape. And I'm going to give you a sense of what's actually happening in healthcare right now. Again, in 2024, when this is when I did my first presentation to this board, a lot of things were more hypothetical and early testing, and that's still the case in a lot of direct clinical care. But we've seen a lot of advancements in clinical decision support and a lot in healthcare triage. And California itself has seen a lot of movement in the space related to AI being utilized in nursing care or nursing services, and we'll touch upon some of the legislation that was enacted in response to that. So currently in AI and healthcare, the big players are really your big four players that I think we've all come to hear. You have Google, we have Microsoft, Anthropic, and OpenAI. Google has been doing a lot in this space, but most recently they announced and put out to the public MedGemma 1.5. The one thing I'll highlight about MedGemma is that this is an open source medical AI, meaning anyone who signs up and agrees to the terms of service can download and use that tool. So that is something that is available for the public. And I have actually used this in a tool that we have worked on here related to complaint triage and providing boards, seeing how effective it could be at providing boards high-level overviews of medical records for quick triage as opposed to incurring the expense of significant medical review. Google's also known for developing AMI, a diagnostic dialogue, and there's actually some clinical trials going on there about the efficacy and accuracy of that whole system. It's not just an AI, but it's a whole system built around AI. And it has performance, at least in early studies and early reports, and again, these come from Google itself, that it's performing comparable to physicians on initial diagnostics and reasoning. From Microsoft, we have Dragon Copilot, formerly known as DAX. Many healthcare providers have used Dragon in some form or another throughout the years. But Dragon Copilot from Microsoft, this is the newest version from Microsoft, and this is a fully integrated clinical decision support. It has ambient listening, AI-generated note-taking. It's been deployed in over 400 organizations. And so it's more focused on providing an actual kind of an EHR experience to clinicians, whereas Google is focused on the role and seeing how AI could be a healthcare provider itself, kind of provide clinical support itself. We have Anthropic, who in January of this year announced Claude for Healthcare. This is a little bit more similar to Microsoft in that it's directed at healthcare providers, but it is more like kind of a ChatGPT experience, but with a lot of healthcare information and things built into that. It does clinical documentation, some admin support, and there are some major health system partnerships that are currently underway. And then we have OpenAI, who just announced recently a partnership with Be Well, again in January of this year. And if you've had a chance, if you have an OpenAI account with ChatGPT account with OpenAI, you can sign up and get access to ChatGPT Health, which I myself have done. And it's direct to consumer. You can upload your any kind of healthcare information, your medical records, X-rays. You can even plug in through Be Well, which provides access to health records, various hospital systems, so that it can actually process and review your medical records. And be very clear, they say they're not providing medical advice; they're providing health advice tailored to you. And so I think that is starting to, and again, we'll touch upon it, but I think this is one of the things that boards are really going to have to be a lookout, is that direct to consumer model and how that is blurring the traditional definitions of what is the practice of medicine. And this is really bypassing our traditional care delivery models. Again, direct to consumer, get your healthcare information into the AI and let the AI offer you that guidance and that advice. I'm going to talk a little bit about ambient listening, because this is by far probably the biggest adoption of AI across healthcare. 1 in 3 US providers are using ambient listening at this time. And for those that may not be aware, ambient listening is a tool that listens to the entire patient-physician encounter, generates clinical notes, and depending on the integration that ambient listening tool has, it could update your EHR, like I mentioned with Dragon DAX, and in some cases even offer and suggest follow-up care or follow-up treatment plans for the patient. And again, that's where we're seeing a blurring of the line between general administrative work versus healthcare. We have a tool designed for note taking and documenting and populating records, and then is slowly being trended towards actual healthcare. 150 health systems that have adopted this, and there are 100. I don't know why we have 2 of the same slides there, but there's over 150 health systems that have adopted this, and it brings up a lot of questions. And there's hyperlinks. I believe the materials will be shared out there, but there's hyperlinks to the actual background research and statistics on this. But again, this brings up a lot of questions for regulators. Who is responsible when AI misinterprets, let's say, an audio or an interaction? A lot of clinical discussions may veer off into non-clinical practice. And so how do we ensure that the AI is only capturing the clinical portion and not populating the record with information that's not relevant, let's say talking about your pet and your pet's health systems that they've symptoms that they recently had? How do we ensure that that doesn't happen? Is the patient consenting to AI? There's some already examples of clinicians, including other professions, at least one case of a physical therapist disciplined for failing to get patient consent prior to the AI, and then further actually lying about the use of AI in that system. So that brings up ethical considerations. And then lastly, data privacy. What happens to the audio data? The audio is being transcribed, turned into a text to be entered into the medical record, but what happens with the audio? Arguably for some quality assurance, it probably gets maintained for a little bit, but is it maintained on hospital systems? Is it maintained in the cloud with these tech developers? So these are a lot of questions, and these are questions aimed at the regulators to consider the impact on regulation and the practice of medicine. But these are also questions for healthcare providers, and when they're out there looking at vendors, what tools to use. And so ambient listening, as you can see, is quickly expanding. It's quickly being picked up and adopted, and is by far the #1 use case of artificial intelligence in healthcare today. So this also brings up, and we've touched upon it quite a bit, is the issue of direct-to-consumer AI, or I should say the consideration of direct-to-consumer AI health services. We've got, again, tools like OpenAI, Be Well, Amazon One Medical, which is not a new platform, but in January of this year, they began implementing AI features into their traditional telehealth primary care platform, Amazon One Medical. Hippocratic AI, you may have heard of it. This was a tool. It has 300 AI agents, which cross healthcare providers, nurses, care coordinators, health coaches, and all of these are designed really to be direct to care, direct to patients tools. And these are arguably from more traditional, I don't want to say fair play, but from your larger companies who have incentives to ensure they're complying with regulations. They're looking to expand legitimately into healthcare. But then we have our bad actors. There's Dr. Martin Shkreli, who, if you do a quick Google, you can see some history on him related to some drug pricing. But Dr. Shkreli got into the AI space very early and created a website called Dr. Gupta, where you could go provide your medical records, upload information, and ask it for medical advice. It was not a very accurate AI model, and in many cases, when you asked it what kind of healthcare experience it has, it would tell you that it was a physician. In reality, it was not. It did not appear to have any physician supervision at all, either definitely not during the active use case, so you weren't being monitored, and does not appear to have any afterwards. I will say it does not appear because that site is no longer there. And it may just be a coincidence, but I will say that this website disappeared shortly after California passed legislation actually banning AI from using professional titles like doctor or nurse in their claims or in their terms of service, or even just how they're acting. So again, this brings up the question: when AI provides what looks, sounds, and functions like medical advice directly to consumers, we have the question of whose jurisdiction is that? We talk a lot about FDA and other organizations and their role in improving medical devices or software as medical devices, but medical boards regulate the practice of medicine. And so when this technology and the actual practice combine and meet, what happens there? So we've kind of proposed not proposed, but we've really kind of outlined these 4 regulatory concerns, or risk framework, if you will, that you really should be watching out for when it comes to AI tools in healthcare. The first, being the most obvious, is just poor implementation. The software has got flawed programming, inadequate integration, it has incorrect clinical guidance, and has really no way of doing any kind of quality assurance to make sure that the clinical guidance it has, whether it be correct or incorrect, is flagged or corrected. The second regulatory concern is really focused, and this one falls more under medical boards' responsibilities, is professional duties. The role of the physician in healthcare and what level of accountability they have, what level of transparency needs to be given, and ideally obtaining informed consent, especially when using AI-assisted care or providing AI-assisted care. And I differentiate that between using AI in administrative software or administrative purposes to providing us AI assisted care. And I used to use the traditional example of ambient listening, but as I talked about earlier, ambient listening is starting to be combined a lot with clinical decision support, which is leading to again a blurring of line of what is administrative and what is the actual practice. We talked about bad actors, so another thing to be concerned about is weak security, deliberate exploitation of patients. So potentially just trying to get them to provide you medical records, as we've seen, various social media websites asking individuals to post medical records, which then can be used for training purposes, and false accuracy complaints, which we'll highlight here a little bit in a second. And then lastly, probably the most commonly known regulatory concern, at least amongst the general public, are AI hallucinations. And this is essentially confident output that is just simply wrong. And this can be quite dangerous where peer review is retrospective, which in many cases is the situation in healthcare. The legal field is just full of examples of AI being used in legal pleadings and hallucinated citations or facts, and they get caught because of the adversarial nature of law. Healthcare is not the same. You're not practicing healthcare against another doctor or against a disease that's really trying to say you're right or wrong, except for the fact that the outcomes could be quite terrible. So a lot of times they don't get caught until afterwards, until they're brought to the board. And so what role does the physician play in making sure those hallucinations don't occur or spotting those hallucinations before they become a problem? So let's talk now a little bit more about the US AI regulatory landscape. So really, the landscape is essentially a vacuum. As you may be aware, the fundamental problem that AI is facing both in healthcare and elsewhere is that there is no comprehensive federal AI legislation, and there's really no comprehensive AI legislation, period. States are filling the void, and in fact, 47 states introduced bills, about 250 were filed last year, 33 were enacted across 21 states. But all those laws are different. There may be some similarities, but they all have their specific nuances. This patchwork creates compliance confusion. It creates barriers to innovation. Companies can't build 50 versions for 50 states. And then, quite honestly, it also creates equity gaps. Populations needing access the most are, quite honestly, the least likely to get it because of deployment considerations. And quite honestly, even legislative barriers. The federal government actually put in place for the president's executive order on this to go after any state that is enacting laws that impose significant barriers on AI, that those states would see less funding for example, broadband access. And so a lot of rural areas that need the broadband access to get that are going to have to agree to fewer regulations on AI in healthcare, and then are more likely to see those healthcare tools that don't meet the standards we see or expect for treating patients. A federal framework, and I would emphasize, a federal framework would provide a baseline. This would not replace state authority when it comes to healthcare. That obviously the federal government and this administration could argue the opposite. But this is really the intent, and the goal hopefully would be to create a floor that really allows innovation to scale, but while ensuring that there are patient protections in place. So let's talk a little bit more about the legislation, and really in particular how California is leading the way in that space. There are several pieces of legislation that were signed. We have SB 1120, and I won't go too in depth. Again, these are all hyperlinks and you can click on them. But that one deals with supervision, physician supervision of AI and medical necessity determinations. Essentially, that there must be a physician making that determination. AI cannot do that. AB 489 empowers boards to enforce title protections against AI. I mentioned the Dr. Shkreli issue and the legislation passed against those title protections, or enforcing those title protections. SB 53, this is the Frontier AI Transparency, Safety, Testing, and Reporting. This really goes a lot to providing a lot of information about how frontier models are trained and built. We've got AB 2013, which is an AI training data disclosure requirements. This goes even further and states that the training data must be disclosed, but I think is very important, especially when we start to come to healthcare models. I always talk about the 3 E's of licensure, physician licensure. That's education, experience, and examination. So that's, you know, your medical school, where you did your residency and did you pass the USMLE. And so when we're looking at, you know, medical models, how do we know that they're trained on quality healthcare data? And so that's where this transparency is very important. And it's great to see that California is leading the way on that. We've got AB 3030, which is patient disclosure for AI-generated communications. This essentially requires disclosure to patients for those said communications. And then we've got SB 1047, which was vetoed. This is the only one that was vetoed, but this was a safety assessments for large AI models. And I want to say on the veto one, you know, the AI safety bill that was vetoed, that veto wasn't necessarily a rejection of AI oversight. And I think that's quite transparent from all the other pieces of legislation that were passed. But at the time, that was really a bill that the governor had stated that he wanted more targeted sector-specific regulation as opposed to a kind of sector-wide expansion approach. And I see that California is definitely doing that, especially when it comes to healthcare. So I think this is, before we get into the doctronic example, I really want to highlight FSMB's work in this space when it comes to AI and our 6-pillar AI policy. And again, I would highly encourage everyone to go read our formal policy. And it was adopted by our House of Delegates back in April 2024, which all boards voted upon, including this board. Although I don't know if you were present at that one, so I'm not going to say if it was voted for or against. But it was adopted by the overall House and is now a formal FSMB policy. So the first pillar, number 1, education is critical. Physicians must engage in continuing education on AI. AI is embedding itself into every facet of life, and especially every facet of healthcare. And becoming educated and up to date on what AI can and cannot do is critical to ensuring that both physicians and patients don't fall prey to bad actors, to those hallucinations, to those really 4 categories of risk that I had identified earlier. Number 2, physicians do remain accountable. Ultimate responsibility rests with licensed physicians for healthcare. California itself, I think, has acknowledged this. There was an opinion from the Attorney General of California, and I'm paraphrasing here, but essentially stating that healthcare is the domain of humans, and only licensed humans, and only humans are licensed to practice medicine, and therefore an AI cannot engage in the practice of medicine. Consent and privacy. So again, patients need to be informed, and there needs to be rigorous data safeguards around the data and how it's used in AI. 4, addressing bias and access. This is identifying and mitigating bias and prioritize equity in the care and equity in the models. And I know equity in certain times is taking in a specific viewpoint, but when we talk about bias and equity and access here, we're talking about very, very direct things. We're talking about ensuring that the model that is being used in this specific patient population is designed for this patient population, because there are differences between population 1 and population 2 that could take account and affect the accuracy of these models. 5, anchor in ethics. This is really a big one, along with education. I mean, they're all very big, but this is the second big one I always stress is focus on the principles, not the specific apps. The technology is not really the expertise of the board, and it's really the expertise of only it's so out there and it's changing every day. There's only a few who have true in-depth expertise. So focusing on ethical principles will really help guide the regulation and help guide the practice of medicine. And then lastly, collaboration is key. Partnerships between physicians, healthcare systems, and regulators can really help create a system in which everyone thrives. that we see some innovation, we see increased access to care, and we see that all done in a safe and humane manner under the regulation of medical boards and others. But let's quickly go through the Doctronic, and I want to highlight this as a case study of really one of the new things that we're seeing this year in 2026 in Utah. So what is Doctronic? Well, Doctronic is it is an online direct-to-consumer AI that is entered into a mitigation waiver agreement with the state of Utah's Office of AI Policy. It offers $4 prescription renewals for about 190 medications, and it is completely AI driven. There is no clinician involved in this. It is only for renewals of existing medications. It is not for new medications. It cannot change dosage of those medications. And if it flags anything that looks out of the ordinary, it goes directly to a human to do that. This agreement, this mitigation waiver, was entered into between Doctronic, the company that provides this, and the Office of AI Policy, which is not a healthcare office, but it is a tech innovation office. And so what happens when you have a tech innovation office waiving regulatory requirements from a healthcare regulator, not involving the medical board? What kind of situation does that lead us to? This is a 12-month regulatory mitigation agreement. It does have an option for an additional 1-year extension. And again, this was announced in January 6, 2026. There are some reports that are supposed to come out from the Office of AI Policy outlining its success, how many prescriptions were approved, how many were denied, and at the end of the project, a larger report. So we're keeping an eye out. We're monitoring that to see where the report goes. But really, the question here for us is really, what is the role of medical boards when these tech agencies are really the ones deciding who can and arguably cannot practice healthcare in a jurisdiction? So how does the Utah model work? I really highlighted it there, and I'll kind of go through this already, but it is a 3-phase model. So at the very beginning, for the first about 250 prescriptions, there are manual human review, 100% human review. So it does get completely reviewed by a person. After those first 250, there's a reduced percentage of review based generally. I cannot remember off the top of my head what that percentage is, but it definitely reduced significantly from 100%. And then phase 3 is a risk-based only approach. So really, those are just post reviews based on the risky prescriptions and whatever incidents may have been flagged. And again, this is a high-level overview. As myself, we're still waiting on data to see how this turns out. So there may be much more nuance that's involved in all of these processes. I mentioned the 12-month regulatory mitigation period. This is known as a sandbox concept. And the idea is to carve out a small sandbox to let these developers play with these tools. Play is probably the wrong word, but test with these tools, see how accurate and successful they are, and then also work with regulators to outline, well, these are the risks that we see. What would be the best type of regulatory scheme to implement this? The one thing I will highlight here is that this is not necessarily this is not a controlled trial. First off, anyone can sign up. So this isn't a small patient population. If you live in Utah, you can sign up. This is also not geographically small. This is statewide deployment. So to call this a sandbox, in my opinion, is a little, it's quite larger than that. I guess it could still be a sandbox, but they've put sand in the entire state. And we've got policies from both the AMA and the UMA who have raised concerns, the Utah Medical Association, that is, about the exact scale of this. So again, why does this matter? What is the implication for medical boards? One, if AI companies, again, get waivers through AI policy offices instead of medical boards, what does that mean for patient protection and the role of medical boards? And it may be the legislators' decision that that's how they want to do that, and that's their prerogative. But then the question is, like, how do we then ensure that the healthcare that is still being provided through the initial provider matches up with whatever the AI tools are doing? How are we integrating that care? Scale without control. I would argue that a true sandbox is small and monitored, This is truly a population scale deployment with a pathway to reduced oversight. Again, this may end up being a legislative, this is the decision that the people want to go. But I think, having understanding of what a sandbox is or what you believe a sandbox is may not necessarily be what other people think a sandbox is. So be aware of that context. The practice of medicine is at stake. If AI-driven prescribing expands without board involvement, it does redefine who oversees the practice of medicine, not just who regulates technology. So I just want to emphasize regulatory sandboxes can drive real innovation, but scale really does truly matter. When anyone in a state can sign up on day one, that's statewide deployment, not a controlled test. An analogy I always like to point to is airlines. Back in the early days of aviation, they really, when they started implementing, these policies and regulations for governing flight, they were showing and estimating a very, very low percentage of incidents. But with something that could potentially result in death or loss of limb or otherwise significant health issues, 1% is not, across a huge scope, is quite significant. So it's just something to think about. And the AI tool could be, and I want to be very clear on this. This tool could be amazing. It could be a 100% great tool. But I think these are considerations to take into context when we start thinking about what is a sandbox and what do we want a sandbox to be, and what role does the medical board want to play in that sandbox. I'll leave you with a couple of other pieces about enforcement actions that we've seen. There's a case known as the Texas Attorney General for Pieces versus Pieces Technologies, this is the first known AI healthcare enforcement action in the United States. This was a ambient listening tool. The company claimed a hallucination rate of less than 0.001%. The Texas Attorney General claimed that was false. No payment of any kind of fine came out, but there was a settlement reached. There was a 5 years of monitoring, mandatory correction plan, and consumer protection laws. Really, the biggest outcome was making it clear that consumer protection laws apply to AI, at least through the settlement. If something were to go to court, that could be different. But I think Texas has really shown that consumer protection laws should apply to AI. And there's even been some legislation at the federal level that's been introduced that would clarify that and expand that consumer protection laws do apply to AI. Whether or not that goes anywhere, we'll have to see. But the question I'll leave again is consumer protection enforcement by state attorney generals doable at scale for AI systems? This was a case, but what about the next 1,000? What about those focused on healthcare versus physical therapy versus architectural engineering or many other professions? Do we want that all funneled through the Attorney General's office? And are they really the ones who have the expertise in matters that are many times really more of an administrative area? I'll end about the quick overview about the Office of AI Innovation at FSMB. We are really evaluating, building, and guiding so boards don't have to start from scratch. We realize resources are a big concern in this space, and so we are trying to do our best to help alleviate those resources, do that research, and share the lessons that we've learned. So we evaluate, test AI on real tasks. We build prototype tools. I built a complaint and triage tool that I've mentioned to this board and demoed elsewhere. And then we publish policies on AI. What we're testing, again, AI-assisted complaint triage. Can AI help prioritize intake? Can it review complaints? Can it even provide a high-level medical overview? As you see there with a document summarization of medical records, complaint narratives, maybe even providing a medical history. We're looking at its use in statute and regulation analysis. So trying to map complaints to practice acts, also identifying public board orders and trying to categorize them for reporting to the National Practitioner Data Bank, which maybe some of your staff are aware can be a quite tedious and cumbersome process, especially when you've got large numbers of them. And then we're looking at risk scoring models, using AI to look at practices and see if there's a risk score, or same thing with complaints as part of the triage process. How risky is this complaint? How risky is this behavior? How we build, we're flexible. We look at cloud, but we also look at on-premise development. So essentially open source models, whatever really would meet the needs of our boards. We understand that some boards like California are much larger and you may have the IT resources versus others that don't and really just need a plug and play system. Again, we're technology agnostic. not just to open source or commercial, but we don't have a preference for any one model versus another. We do believe strongly in the need for human in the loop that AI supports, but humans are the ones to decide. So even with the AI assisted complaint triage tool, that is really just a tool to assist in the process. It's not there to take the human decision making out of it. And then we build board specific, or we design board specific. We're looking to tailor these tools to whatever regulatory workflow that works for you or for any board. So designing those tools and making sure that they can be flexible and they can be adaptable. And then lastly, sharing what we learn. I've done 30 plus presentations on AI regulation since 2023, along with 40 countries represented at IAMRA, the International Association of Medical Regulatory Authorities. We've engaged with 5 national organizations. We're presenting again with IAMRA, organizations CLEAR and FARB, which are cross-sector regulatory conferences, and then individual state boards like this one today. And again, as far as what we're sharing, as you've seen, we're sharing what AI can and can't do for boards today. We are focused on privacy first architecture patterns. So how to do that for boards, how to ensure that only you maintain privacy over that data and you're only sharing what you want to share. And then really helping some of our boards when they're out there trying to get vendors to build these tools, or what vendors are out there to provide these tools. What are the questions that you should be asking of them to ensure all your goals and needs are being met? So again, our key takeaways, medical boards are frontline AI regulators, and I will emphasize that is by necessity, not by design, because when AI performs medical functions, boards are the only ones that regulate the practice of medicine. We've talked a lot about California leading the way through the legislation. You've really created probably one of the most comprehensive AI healthcare frameworks in the nation, the state of California has. We've talked about the doctronic precedent and being aware of sandbox and scope and what role medical boards play in those programs going forward. And lastly, and probably to me anyway, most importantly, is that AI supports humans decide, whether it be clinical or regulatory. AI really does work best handling structure and speed, while humans apply what you're best at, which is expertise and accountability. So I'll end it there. There's my contact information, link to my LinkedIn profile where I post regularly on AI regulation and everything else. I'm probably used up more than my time, but I'm happy to answer any questions that you might have.
Thank you, Mr. Myers, for that incredibly informative presentation. I think for me personally, it's equally exciting in terms of the opportunity and then terrifying in terms of the risk. So I'll open it up to board member comments or questions. Any comments, questions? Dr. Ayala Rodriguez.
Thank you so much. And thank you for the presentation. One of the comments that you were sharing about, like, where does the audio end? Like, that got me thinking about the medical records. Like in the AI world, where typically those transcriptions are based on recordings, and those could end up in clouds, that could end up in the sponsoring third-party vendor that holds the recording. Do you know, like, if that is something like considered part of the medical record, or do you know if that is like something considered, something supplemental to the medical record, and the actual medical record is just what it's in the electronic health record? Any thoughts about that?
That's a great question. It's actually come up in a few conferences we've had. Is what does the medical record look like? It's probably flipped on its head. Is what does the medical record look like in the age of AI? How much, when you can populate the medical record with an entire transcript, do you just throw that in as part of the medical record? There's really no definitive holding on that. I mean, a lot of times what defines what needs to be in medical records is defined by state legislation or rule. But it does bring up a lot of questions about if you, say, have a complaint against a licensee and you want to obtain the medical record. I think medical boards and really anybody needs to start thinking about subpoenaing the audio recordings, especially in cases where there may be allegations of improper behavior, other substance abuse issues, or anything that may have been caught in an interaction that could have been on audio. Because I don't think anybody is really paying attention to any of the agreements on how long those recordings are being kept. No doctor that I've ever asked could tell me how long the audio recordings that record their sessions are being kept. And I don't know that they have to, but I think that is something that needs to be considered.
Additional comments, Dr. Mahmood?
Yeah, it's so interesting. It's evolving so quickly, and thank you for the presentation. My question is on the AI medical management part. How would the medical, legal, and other arbitration, when things are across the state line and even across the ocean line, like different countries are managing things, how are we going to manage those, and how are we going to discipline those, and how are we going to feel the consequences if something go wrong?
I think it's a great question. I think it brings up one of the most interesting things that has occurred since I've started working in this space was when I first started, and it wasn't that long ago, but there's still the principle of how the standard of care may be different in different jurisdictions. But as medicine has advanced, that's become less and less. The standard of care has kind of become more uniform. Not always. Rural areas, I guess, most definitely suffer a different kind of standard. But to your point, because we don't have comprehensive federal legislation, we're seeing some states like California do one thing, Washington do another, Florida do another. So what then becomes the standard for use of AI in different jurisdictions? And then what do you do with continuity of care? You're leaving from one jurisdiction to another. How does that work? These are questions that really don't have great answers, if any answers, because we are just in the Wild West and the states are all approaching it differently. And a lot of the adoption into healthcare, I think we're seeing it right now, arguably because the models have gotten better, but also because I think a lot of the companies have been holding off because they were hoping for some regulatory clarity. And I think they realize that's not coming. So they're just going to go and push and see what they can get away. I shouldn't say get away with, but they're going to try and put their products out there and let the regulations and everything develop around them. So long-winded way of saying I don't have a really good answer for you. And that's separate and apart then from looking at what kind of liability may exist for malpractice purposes or products liability versus state A versus state B versus state C. And that's not even taking into account then when we start looking internationally. In the EU, they have the GDPR and they have their more comprehensive AI regulation. China's way, way stricter on AI use and arguably a kind of ahead in that space in its regulations. So, we're hoping, everybody that I speak to is hoping for some sort of federal oversight. But what that looks like, nobody can agree on.
Any other questions or comments, Ms. Torres?
I know that just last year, I think there was some guidance that came down from AG Bonta's office with regard to the application of California Consumer Protection Law to AI. But that was just last year. I mean, do you know what the status of that is? And is, any other next steps that we can look forward to hearing from here in California?
I can't speak specifically to California on next steps. Obviously, California is California. The legislation may go one way or another, or the policy may go one way or the other, especially as the national winds are changing. Because again, I mentioned Governor Newsom vetoed that original bill, but then we saw some more focused bills. And I think, quite honestly, as the technology gets more capable, people's fears are rising. Whether they be justified or not is a different conversation, but people's concerns are rising, and the polls show you there's a strong interest for regulation and oversight. So I imagine there will be more of that, but what form, I couldn't tell you. It's something that we keep trying to monitor. And if you're really interested in monitoring all statewide legislation, there's a great health tracker from Manatt, M-A-N-A-T-T. They do a nationwide AI healthcare legislative tracker, and it's really comprehensive on what's going on. It'll show you how kind of chaotic it all is, both in terms of what's being introduced and then what gets passed. Because what gets introduced is sometimes even more entertaining to read than what gets passed.
Additional comments, questions? All right, Dr. Ayala Rodriguez.
Thank you. By any chance, do you know if there's any state medical board that has issued like specific guidelines or best practice publications into how to implement AI? Because like as you were like presenting, one of the things that I was considering is that in a new field or in a new or having like new tools available, many times it's like who has some form of ownership or accountability to monitor a process, and many times not making a decision or not providing information or guidance, that is a decision. It's like you're allowing someone else to come and provide the best standard. And maybe, for example, that is something that happens at UT. It's like there's no stance from the board, and someone else says, well, I want to have some form of authority over it and go and provide my guidance and my freedom of work and things like that. But then that goes into the gray area. So for example, for California, I'm thinking about how can we provide some form of guidance? Yes, there's many things that are controversial, but there's also many things that are best practice, like having a business associate agreement, about like record keeping, about when we use AI for translation, or not for translation, but for the documentation of the note. Like, have you seen any other state board meeting, state boards providing some form of formal guidance that has been
Sure.
published? Yeah.
So I'm aware of Washington State issued some policy guidance back not too long after we had adopted and issued our OAI policy. That was back in the early days. It was, it was more of a high level and really emphasized, again, like we do in ours, is about the ethical requirements, professional requirements, creating a best practices that get down to the very specifics. On some tools can get kind of crazy because, again, they change. Like what you could do today versus last year, that alone is insane to me. What you can do today versus what I could do last week. If you've been following the space with agentic AI and what that is doing, I've been following this since ChatGPT first came out, and this is the first time where I feel like AI is at the point where it can truly start, good or bad, replacing people in workforces. What you can let it independently do and come back with you is quite crazy. So we, our recommendation is, again, focus on those high level things, because otherwise you're just going to be constantly following up and trying to battle about best practices. The medical records issue that was raised, and I apologize, I don't know I'm already forgetting who raised that question. I didn't catch the name. I think that is one of the areas that guidance is really needed on, that has not been provided. Really, I'm not seeing a lot anywhere about what should go into the medical records if it's AI generated or AI incorporated. And I think that is something that could be really useful. But if we're talking about, AI and cardiac care usage and what you should or shouldn't do, I think that's something that probably should come from like ABMS or the specialty societies. And we've been involved with some of those discussions about, what role do they play in these situations. And then, quite honestly, there are third parties like CHAI and others that are like these assurance labs that are trying to come out with best practices, but those are kind of a politically DOA based on the current administration's viewpoint of them. So again, another long-winded answer to, I'm aware of Washington, but a lot of them are just still very generic policies. I could definitely do a little bit more research and try and see what I could share it with you if the board would be interested.
Thank you. Additional comments, questions from board members?
Thank you for the presentation, Mr. Myers. Going, in addition to Dr. Ayala's comment, have you seen other state boards, and I know this is an evolving topic, but require CME or just suggest CME? Because you mentioned about education is very important on this topic, and and you outlined different laws, especially here in California, especially regarding consent and so forth. So I wanted to know if you've seen that in other state boards issuing those type of guidance or CME requirements.
I've not seen it adopted yet. I've seen it discussed plenty of times. Everybody brings up but as you probably have experienced, anytime new CME tries to get added to existing requirements, there tends to be a lot of pushback about. But and as a former, I should also say I used to run the District of Columbia Board of Medicine. And so, you know, I've had to deal with the CE, and I could, you know, personal experience, some CE are better than others, but I believe strongly that AI is a category that it is one of those things that everybody really needs to learn about. Now, what level, what degree, the amount of hours, you know, it varies. But you know, all major health systems are implementing these tools in some facet. And if you really aren't aware of how they work, you're gonna miss the little things. And so, again, a lot of them have been talking about it. I'm not aware that of anybody that has enacted them. We have our annual meeting in April, and I plan on the FSMB is going to have our annual meeting in April, and I plan on making the rounds and trying to talk to as many people as I can to get as much information as I can on this. And continue doing some research. So again, whatever I find, I'll be happy to share with the board.
Any other comments, questions from board members? All right, let's open it up for public comment. Are there any public commenters in the room? Please.
Hello, my name is Lucas Evanson, speaking on behalf of the California Medical Association. CMA recognizes the tremendous potential artificial intelligence holds to improve efficiency in healthcare and reduce physician burnout. CMA also recognizes the importance of the doctor-patient bond in delivering high-quality, cost-effective, and safe care. All technologies, including artificial intelligence, should enhance, not degrade, this relationship. CMA has pursued policies when we think this principle is being undermined. CMA was proud to sponsor both SB 1120 by Becker and AB 489 by Bonta, mentioned in today's presentation, which help ensure appropriate oversight and transparency for AI use that impact healthcare delivery. This year, CMA is sponsoring SB 1146, authored by Senator Lana Gonzalez, to crack down on the growing use of artificial intelligence to create deepfake impersonation of physicians. The bill seeks to protect patients from misleading medical advice and fraudulent advertisements that weaponize the trust between doctors and patients. This bill was just introduced, so we hope the board will consider supporting the bill in a future meeting. But we appreciate the board's attention to this important and rapidly evolving issue, and thank Mr. Myers for his informative presentation. Thank you.
Thank you for your public comment. Are there other public commenters in the room? All right, seeing none, Sean, if you'd open it up online, please.
Yes, if you'd like to make a public comment on agenda item number 5 here, please do so by raising your hand or just typing anything in that Q&A window. We'll get you called upon. First up here, we have Rob Gordon. Rob, you should be receiving that prompt.
Hi, Sean. Can you hear me?
You can. Please go ahead.
Yeah, I don't even remember if I mentioned it in my opening comments, but we on the opposed Medical Board of California, or excuse me, abolished Medical Board of California. We do have an AI system on there. It's Google Gemini. We have loaded, I think I'm up to 3 years so far, all the transcripts for these meetings. So if you can remember a few months ago, I told you that I was able to prove that you have not, those ways you start the meeting would say, the only thing we can do is consider items for future agenda items. You have never done that, not once, not ever. Yeah, I noticed you didn't say that anymore. So so maybe that's a possibility. But I want to mention that that's there, and we will be working on it more. Now on to Mr. Myers' presentation. I've had I've corresponded with Dr. Sutton, who is one of the people the medical board went after for a very small number of vaccines they didn't like. I don't know everything about the case, I'll say that much, but I do know that she lost her her medical license in other states because of the FSMB or whatever your name is. You know, once that's like the mafia or something. That's unconscionable. That's just morally wrong. That you have a clueless board of directors here again, not individuals, as a group, absolute idiotic, does everything wrong almost, and they can decide somebody loses their license for all other states. That is just immoral. Mr. Myers, you talk about regulations just like, you know, you're the king coming in there. These are already our kings and queens. You didn't even mention the people. you really don't have the legitimate reason to be regulating. You're not the government, you're a private association. So what you're doing is just morally wrong, and I consider what you're doing interfering with California politics, and I ask you to stop. Thank you for listening.
Thank you for your public comment. Next up here, we have Eric Andrist. Eric, you should be receiving that prompt.
Hi, my regular disclaimer that the CMA does not represent a majority of doctors in California. Most choose not to be members, and there's a good reason for that. A majority of the doctors currently on this board are not members. I believe Dr. Yip is the only one now, but I could be mistaken. It's interesting how you'll allow Christina to agendize these long, boring presentations that only peripherally relate to patient safety, but never question the long list of agenda items that are suggested for patient safety that never make it onto the agenda. I would recommend to the new board members that you go through the minutes of a lot of the past meetings and make some notes about what has been asked for, and then try to find the ones that actually make it onto the agenda. In fact, if you download all the minutes, you can put them into AI and have them do the work for you, and it will write the report and let you know just how many agenda items Christina is not allowing to appear on the agenda. Use AI for that. That'll be an interesting discussion at one of the upcoming meetings, won't it, Christina? I've done that for the next agenda item, so I'll be right back. Thanks.
Thank you for your public comment. Getting some requests on the Q&A, people typing long format questions. Just if you'd like to make a public comment, all you have to do is state your name there or raise your hand there. I'm going to try the first one to see if they'd like to make a public comment here was Christina White. Let me see if I can still find your name here in a little bit. I'm sorry, Cassandra White. Cassandra, if you'd like to make a public comment, please go ahead and accept that request.
Yes, thank you so much. My name is Dr. Cassandra White. I'm a physician here in Northern California. And my question was for Mr. Myers or even potentially board members. But what do you see as implications or impact for medical boards when it comes to case reviews and formal complaints against physicians, where there may be potential for erroneous medical record documentation with the use of AI technologies? And what would be some considerations that you would consider? Thank you.
Sorry, doctor, you have 3 minutes to make a public comment, but we can't go back and forth with you. So if there's any additional comment you would like to make, go ahead.
No comment. That was just a question, but maybe just something to consider, like how this would potentially play when it comes to case reviews and complaints. Thank you.
Thank you very much for your public comment. The other person who typed in the Q&A window declined to make a public comment, so at this time I don't see any additional requests.
Sorry. Great. We'll bring it back to the board. Any further comments from those those present in the hearing room? All right, seeing none, we'll close the public comment period. Any further comments, questions from board members? All right, seeing none, thank you again, Mr. Myers, for your very informative presentation. One thing I appreciated was, the notation that California is leading the way, and I think there's an opportunity for us to continue to do so. I mean, even in the vein, the last commenter, asked a question, kind of, what are we going to do about all of this? And I think that's something we need to be thinking about as we go forward. And it's probably the type of thing, given how fast things are moving, that deserves a standing agenda item on our agendas going forward. So in any event, we will move on to agenda item 6, executive management reports. We're going to take all questions and comments on these reports at the conclusion of all the reports. And Sean, I think you're starting us off. If you can get away from your WebEx screen there.
Over here today. Thank y'all. Just a brief update from ISB right now. Staffing updates. We're making progress on filling a couple of vacancies. Almost got to 100% filled here, but just on Monday, actually celebrating the retirement of Charlotte Clark. She's our website project manager. She's been with the board for 26 years of a 37-year state, career. So we wish Charlotte the best. She's been with the board since the days of the website being like a one-page kind of a thing. So she's led us through multiple redesigns, the state redesign templates and things like that and stuff too. So a big wealth of knowledge in terms of the history of our website and stuff. Leaving us next week, and so we'll dearly miss her, but we congratulate her on her retirement. But we will be working to fill that vacancy and hopefully get us to 100% at some point this year. So infrastructure updates, we've been rolling out new laptops for board staff now after we did HQIU last year and some other infrastructure updates. So working with staff to schedule times to move them over. We expect that project to take about 1 to 2 more months. It's just part of the 5-year plan. We always rotate that equipment to keep it up to date and modern and covered by warranty, so it's reliable for them to do their tasks. Regarding the complaint tracking system, the testing has switched from individual activity complaints to reviewing now complaints in whole with the legal and executive and enforcement units and things like that. Going through lots of complaints, doing just the final fine tuning on that, stuff like that. I've removed the release date. We'd hope to be, launching it here pretty soon. All I can say at this time is that, when the testing is complete, we're all satisfied. We'll be launching that. So it could be very soon here, just depending on how that goes. So I know a lot of interest when that comes there. So we've kind of reached the final stage of user acceptance testing. And so when we're all ready to go, that'll be going live. For our medical board iOS app update, we've added the background push notifications and everything like that. We decided to modernize it for iOS 26, and we wanted the upgrade to be as painless as possible for people, so that instead of having to delete the old app, install a new app, they could simply just update the one existing app. Because of a feature that we've added to sync licensees that you follow. Like say you have an iPad and an iPhone and you want to have the same licensees followed on both devices, we've moved that data to the iCloud storage, which will involve now we're putting in disclaimers when you update the app that it'll tell you all the licensees that you currently follow will be removed. You have to re-add them so that it'll sync across both areas. That is with Apple actually as of this morning for final review. So as soon as we get the green light from them, we'll be pushing that button. It could be even tomorrow, but any day now. So I'm very excited to get that one up and running. All the testing went really well there. So excited for I even tested it on the flight last night just to make sure that we're free Wi-Fi on the airplane worked and everything like that. So with the consultant expert management application, we call it SEMA. We've made a bunch of enhancements there to change some of the rates for certain specialties, things like that, enhance the training tracking that we take for our experts so that they can qualify for those higher rates, automated the contract renewal portions so that alerts go out to the consultants just to let them know in advance so they can start those processes early, take that workload off of staff so they can process the responses when they come back in and be looking for more qualified consultants and experts to review our complaints. So waiting on the testing from that unit to deploy that, but I'm looking forward to getting that out soon and starting a new project in its place. The docs update there is statistical updates only for you. You can see the kind of similar trends in the application documents, the licensing documents. We're still building trends for there, but just more numbers and increased usage. The volunteer physician registry, a few more volunteers added there, but it's just continuing on. The HCI physician survey update, again, just statistical updates there. I just will point out we're up to over 87% now of our licensing population. If you've been around for a little while since that new survey came online, I kind of teased that 90 to 92% is kind of the theoretical limit we think it'll get to. That's where we were before this new survey came out and replaced all the old survey results. So When we see that number kind of taper off, we'll probably stop even including in the updates there, but just to let you know, we're still trending up towards that number ever so slowly. With the Breeze online complaint form redesign, we were supposed to have some new code drop back in October that we were going to be able to configure and finally update some of those screens on the Breeze online complaint form. There were some additional problems found by the Department of Consumer Affairs Office of Information Services that is kind of QAing it before we even get to see it and stuff like that. So the new estimate now is that that will be dropped here about mid-March, and that we'll be able to start working on configuration then, which will probably put now the time frame for updating those online complaint screens sometime around the middle of the year. It usually takes about a month or two to get those changes configured and put into the system. So we'll have another update for you on that one next board meeting. In regards to the Breeze electronic only renewal notice project, again, just statistical updates there. Looks like everyone's getting used to doing their getting their renewal notices online through email, and we saving a lot of resources and not sending everything out on paper. So the print yourself wallet card updates, again, just showing increase there. Same kind of plateau there of use being done. So just this statistical update only there for you. A new project I wanted to mention to you guys was that we're calling the Continuing Medical Education Audit Enhancement. So if you're not, well, I'm sure you're aware, but the process currently is that every month we generate these batches of individuals that get selected randomly for their CME audits. And a few years ago, we converted it over to sending it by email. Since we started collecting emails from individuals a couple of years ago, they're required by law to now report to us that email, and hopefully they're keeping an eye on it. So now that we feel good about the quality of the email addresses we have in the database now, when you get selected for a CME audit, you get an email letting you know that you've been selected for that audit and that you need to provide your materials back to us. And they're able to email those materials back to us, but we're looking to make it a little more streamlined and secure by having an actual Breeze transaction, much like a renewal transaction, where you go in there and you upload your documents right through there. And the benefit of that is that you will see actually there on your Breeze dashboard there the status of your CME audit. So once you've submitted everything and you've done the transaction, you can keep an eye on that there to where it is basically completed by our analysts in-house. It also streamlines things for our analysts in-house too, because instead of having to take those documents off of an email they receive and put it into the Breeze system and mark things off in there, it's kind of already in one place for them all, just for historical tracking and everything else too. So benefits the licensees and staff internally by making it a little more transparent and streamlined for them, hopefully. We're looking in the next couple of months to have that fully rolled out. A lot of the stuff is in place. Just waiting for the last wires to get connected in Breeze, I guess. So that concludes my update. I'll remain up here, but Doug and Shar, if you want.
Thanks, Sean. We will turn it over to Doug Hawk for a licensing program summary.
Good afternoon, everyone. Okay, I'm presenting the Q2 update for our licensing program. In Q2 of fiscal year 25-26, we received 1,567 initial license applications. We also issued a total of 2,506 licenses. We have a couple of form updates. We're always looking and working to improve our forms to reduce errors. The Certificate of Medical Education form was updated by adding 3 new questions to identify non-standard medical school enrollment timelines, including the extended enrollment, accelerated programs, or withdrawals or transfers. This update will prompt schools to provide a letter of explanation when attendance dates differ from the standard curriculum. We also updated our CODA form. Instructions now specify that only CODA-approved clinical training dates should be listed. For our process improvements, we're always looking for ways to make our processes more efficient. The postgraduate training license enrollment form for licensees and the program status update change form can now be submitted through Docs portal. This allows programs to transmit the forms more quickly, securely, and efficiently. Previously, these forms needed to be mailed into the board. For our licensing webmaster, the licensing program responded to 2,882 emails in Q2. The most common topics during this quarter were license updates, initial renewals, and fictitious name permit questions. For our outreach in Q2, we conducted 4 outreach activities, all in person. During these events, we responded to licensing inquiries and guided programs, applicants, and licensees, the licensing and renewal processes. Topics discussed included the new ECFMG requirements for Canadian medical school graduates, PTL requirements, and first and second time renewal requirements. For our consumer information unit, in Q2, our call center received 11,028 calls with an average wait time of 3 minutes. The top 3 topics addressed during the quarter were renewal assistance, complaint questions, and application questions. And that's a quick update from our licensing program for Q2.
Thank you, Mr. Hawk. We're going to move on to the enforcement program summary. I see Charlene Smith making her way up to talk with us.
Feel deserted over here. Good afternoon. Today I'll be providing you the enforcement program update. So we'll start with our central complaint unit. So management and staff are continuing to look at process improvements, paperless, keep praying for that. We're working on bringing down our overall initiation and case processing timelines. We have been successful in making movement in that. Our average days to initiate is 8 for this last quarter. And our average processing time in CCU is 168 days, down from 180 the previous quarter. In the complainant liaison unit, they've completed their inaugural year. Been very exciting to see that program implemented, being a extra addition to enforcement. So there have been 1,969 complaints referred to the complainant liaison unit. 1,518 interviews have been offered. Now, interviews are optional, so we are obligated to meet the statute and offer the interviews. However, complainants do not have to participate in those. There are 192 pending interview offers, and that leaves about 259 out of that total 1,969. And what those 259 are complaints where the central complaint unit had requested authorization forms and had not received responses to their multiple requests. So in efforts to, do our best to engage with the consumers and get responses, we've had the complainant liaison unit attempt again to reach out to those consumers, and we're happy to report that 130 so far have returned those. That's really great. So once those releases are returned, then the complaint then is going back to the central complaint unit to complete the processing. And we are working currently with the information system branch to try to separate out the central complaint unit stats from the complainant liaison unit stats. The reason being is when you look at the overall case processing time for CCU, that includes the time in the complainant liaison unit. So we're working on that and hope to have that implemented soon. For the expert and the medical consultant review program, I'm happy to report that we're always continuing our recruitment efforts. And we would like to thank Dr. Tolbert for connecting us with Dr. Alexander Kalesi, Chair of Neurological Surgery at UCSD. They did have an outreach on the Martin Luther King Jr. weekend, and they did share information about the medical board's medical consultant and expert reviewer programs, and we thank you for that.
Shar?
Yes.
Will you bring your microphone closer,
Oh, I'm
please?
so sorry. Sure. Additionally, we did have through an outreach event that the manager for the expert reviewer program and Reggie, they had met with the the executive director, and I apologize now, I have her name in phonetics, but the executive director for the California Orthopedic Association, Diane Shapadowski, was offered to publish recruitment information about the board, the expert and the consultant programs in their newsletter, their report briefings. So that was really appreciated to help support our recruitment efforts. The Complaint Investigation Office, so this is our non-sworn investigative unit. As of January 1st, CIO has a caseload of about 267 cases, and that works out to about 41 cases per special investigator. And between October 1st of 2025 and December 31st, 2025, CIO closed 43 cases and referred 17 cases to the Office of the Attorney General. This was criminal conviction cases and a malpractice case that were forwarded on to look into filing administrative action. Discipline Coordination Unit and management are continuing to work closely on bringing the out-of-state case aging down. We're pleased to report that they have been successful in doing that. There are currently 131 cases that are pending for the out-of-state discipline, and 17 of those are aged a year or over. So that's their priority, and also staying on top of the new information that we receive every day. For probation during the second quarter, 31 licenses were placed on probation. 4 probationary licenses were issued. 27 licensees successfully completed their probation. 2 probationers surrendered their license while on probation, and 1 citation for probation violation was issued. There were 6 cease practice orders issued for probation violations, and we submitted 6 petitions to revoke probation that were filed, resulting in 1 surrender and 2 revocations, and then 3 licensees were placed on additional probation terms. And then 2 accusations and petitions to revoke probation were filed. And as of January 1st, 2026, there are currently 551 licensees on probation, both in and out of state. Thank you. That concludes my report.
Thank you, Ms. Smith. And we're now going to move on to the administrative summary from Mr. Varghese.
Thank you, President Lawson. So my report starts in your notebook BRD 6D on page 54, I believe. The executive summary that I'm going to present today will only hit the main highlights from the staff reports and the meeting materials. The February 2026 staff report to the Medical Board of California reflects strong operational stability in both staffing and fiscal management. Looking at the staffing, the board's vacancy rate stands at an exceptionally low 4.35%, with only 8 of the 184 authorized positions unfilled. Recent successful recruitment and internal promotions demonstrate effective hiring, retention, and workforce stability. This level of staffing significantly strengthens the board's capacity to meet its regulatory and enforcement responsibilities without disruption. Going over to the budget side, financially, the board is in a strong and stable position. Revenue projections exceed expenditures, and the board is expected to maintain a 3-month reserve at the fiscal year end. Importantly, all prior loans have been fully paid, leaving the board debt-free. This solid fund condition reflects prudent fiscal management and positions the organization for continued operational sustainability without a reliance on borrowing. Outreach and external communication on February 5 and 6 of this year or this month, myself had a chance to attend and present at the California Experience with International Medical Graduates as a topic for licensing other pathways that the California Medical Board follows at the National Credentialing Forum in San Diego. Overall, the combination of nearly fully staffed workforce and a debt-free, well-reserved financial outlook signals a high level of organizational health and readiness moving forward. Now I'm moving over to the strategic plan update on page 19 and 20 in your book. The Medical Board of California continues to make measurable progress under its 2023-2027 strategic plan, with implementation efforts focused on modernization, operational efficiency, and stakeholder engagement. Strategic alignment. The board has initiated updates to the strategic plan to ensure alignment with the governor's executive order on diversity, equity, inclusion, and accessibility, or DEIA, while maintaining momentum on existing goals. Operational improvements. Key advancements include full implementation of online license renewal, streamlined application process, improved coordination between investigative and enforcement units to reduce case delays, and modernization of public-facing resources. Stakeholder engagement and governance. The board strengthened external engagement through structured collaboration with academic and clinical partners and enhanced internal governance through updated procedures, executive briefings, and committee streamlining. Overall, the strategic plan update reflects sustained progress towards improved efficiency, regulatory effectiveness, and organizational accountability, while proactively aligning future priorities with statewide DEIA directives. Madam President, thank you for this opportunity. This concludes all executive management report. Myself and my staff are happy to respond to any questions members may have.
Thank you. Are there any questions or comments from board members? Mr. Portillo.
Thank you. One of the things I was wondering, for the outreach events we did, I mentioned there was 4 events that were done. What was the attendance like at those events?
So myself, I didn't actually attend the events. Rhonda, who is our outreach coordinator, who's out front at the table, she attended the events. I can check to see, but as far as I know, in my follow-up meetings with Rhonda, she spoke with lots of applicants.
Okay.
Yeah.
Do you know if we worked with any either community organizations or elected official offices to promote some of those events?
Yeah, so Rhonda has a list of programs that she contacts each and every year to try to set up events. She also, we do research to find out any new programs and emerging programs. We also get recommendations sometimes from board members and other outside individuals, and contact them as well to try to set up events if needed. We try to actually set up as many outreach events as possible throughout California.
Okay. And then what's the plans for the next, let's say, quarter?
Say the quarter, generally it gets really heavy. I know when we had 4 the last quarter, that's very light. If you look at our outreach from, I want to say probably May through October, there's probably right now, I'd say at least maybe anywhere from like 20 to 30 events scheduled.
Okay. If you're able to share that with us, I think that would be great. I'd be curious about see what some of those, and to the extent that you may be able to kind of work with either some local elected offices, local educational institutions, even K through 12, I think there'd be a lot of interest. You know, with the medical boards coming to town, I'm sure a lot of them have an interest in going into that profession, and to the extent that we can kind of be there and kind of let them know that that's going to be an opportunity, I think you may have a lot of people wanting to participate.
Sure. Yeah. Yeah. If you have any recommendations for us, yeah, please let us know. We can contact those programs.
Okay. And then I did have a couple other items that I did want to check. On the enforcement, I know you said we had outreach events. So what's been the attendance on those similarly?
It's been mixed, it's been light, but we're going to be ramping up through our complainant liaison unit. A portion of their function is outreach, not only for their role is to go over the enforcement process. So the outreach that I spoke about in my presentation was specific to the expert reviewer and the medical consultant programs. So we're always running ads in our newsletter, our quarterly newsletter, and grasping at any outreach or contacts that we have who are willing to fly ads for us or, present, share some slides. So yeah.
I have some suggestions on organizations you may work with on those. I'd be happy to touch base afterwards. And then we mentioned that our investigators have about 40 cases per investigator right now. Is that kind of what the goal of what we want to keep it on, or is that high, low? Where would that be considered?
It's average for them, and that's our non-sworn in-house investigators. That's not the health quality investigation unit investigators, the sworn. So it's internal at the medical board.
Okay.
Yeah.
And then the final 2 questions I had were for our financial reserves. You mentioned they're at 3 months right now. Is that consistent where we want it to be, or do we want it to be higher?
We want it to be higher, and we can go up to 6 months of reserve per the law. But if you look at the prior fund condition reports, we were below 1 month. So this is a good progress. And when we were below 1 month, the future projections were going into the reds. So this is a significant progress. I want to say the momentum should continue, and we should build the reserves. Now, again, some of the projects that we have, capital projects, might when we spend more money, so we'll continuously monitor that. And so 3 is a comfortable zone that I would say, better than what we experienced in the last 5 years.
Yeah. And then the last one was on the strategic plan. When do you expect that to come before the board?
So the board approved the current plan that's going to end at 2027. So if you have not already received the survey for the DEIA survey, if you haven't already taken it, I'm not sure what the deadline for the survey submission. I believe it's end of this month. And at that point, the solid group of DCA that is helping us to analyze all the responses are going to evaluate all the responses. And it all depends on the volume of responses they receive, right? So if last time we had the survey for this current plan, they received an overwhelming response, because we polled not just the board members, but the staff, other stakeholders, licensees. So if they received a vast majority volume responses, that'll take some time to process through. It may be delayed, but our goal is to see if we can work through all the responses and to bring the changes that we're going to be proposing in August meeting. That's the goal at this point, but again, that's not absolute certain at this time.
Okay. And then let me just say, a lot of the information in the packet was really helpful, really great. One recommendation we may want to be as we're going through these, for people who may be watching online or even in the room, if we want to do a PowerPoint with some of the main top level numbers, I think that might be helpful for people who are just watching, or even for us in the room. Thank you.
Thank you.
Mr. Partiello, I just want to throw out that they're posted as materials. Yeah, just the way you got your packet, the public can download them online too. But yeah, we could definitely have a PowerPoint as well. But they are available to everyone, just so you know.
I can recommend to the board, because I did this myself. If you have AI provide a summary, it really does a nice job of giving you the high level bullet points also, so you can focus on them. Ms. Holmes.
Thank you. I appreciate all the information. And yes, I agree, there's a lot of it. So I wanted to ask about the complaint tracking system a little bit more, Sean. So I'm assuming it's multilingual, because you can do that in Google is it multilingual?
It could be ran through. Oh, sorry. It could be ran through Google Translate, just like our website. That's how we make our website.
Okay.
Multilingual as well too.
Okay.
You can pull it up on Google Translate and use it that way.
Okay. So how will this work for those without technology access? So they would just do the usual customary process then, or?
They'll still be able to call. What we're looking for is a reduction in the number of calls for complaint status that we receive, and we'll still be sending out the paper letters and all the current processes that we still do. This is just 24/7 access to the complaint to be able to see the status of the complaint information in there. We know postal delivery is not always successful.
Right.
Some people can't call during regular business hours. So
Right.
Our hope is on a smartphone, anyone could, still get in there. So even if they don't have a desktop computer, things like that, if they have a mobile phone, they'll be able to log in and see the status of their stuff. But yes, all the existing old methods we don't have any plans for phasing that out. We're just hoping to augment them and antiquate them someday.
Right, on demand. It's kind of more on demand.
Yes.
Did you engage with consumers to get feedback on this process?
Yes, if you go back to that presentation we provided in your new board member orientation, we held 2 interested party meetings with any stakeholders, public individuals online that they could call in or WebEx in and provide suggestions on the plan system that we were building and things like that. Off the top of my head, I can't remember the numbers. We had a list of suggestions and recommendations. They were reviewed for legal and technical feasibility. A lot of them were incorporated. A lot of them, though, were deemed information that couldn't be shared at the complaint level. There are parts of the investigation, things like that, that are confidential. They still
okay.
cannot be provided during that part of the investigation and things. But we incorporated everything we had in there. We do have a list of items that we indicated were post initial release because they involved some additional technical hurdle that we didn't have a solution for right then and there when we started coding this thing last year. So one of the things we're looking at is electronic signatures for release forms and things like that right in the system so that you're able to do that and upload files. Where we have kind of a proof of concept project going on with those electronic releases because we want to see hospitals, will they accept them? We've actually gotten some feedback from some other boards and things like that, and information back from certain hospitals that say that they'll only accept electronic signatures from certain vendors and not necessarily the vendor that we're working with and things like that. So we're hoping to question why that is. If the metadata and security is all there, my hope would be that it would be accepted. So a lot of work already going into things that we indicated were release 2 and later kind of things. But right now, the main goal of the system is to take that load off of the call center and the enforcement staff to answer those status updates so they can keep working the complaints and let the status update be relayed through the system.
Okay, just one last request, more than a question, because you may have done this. So I'm curious, since we had this great presentation on AI, what are you doing? Have you already briefed the board on what the kinds of things that you're looking at, opportunities to use it for the betterment of shorter complaint, times and things like that?
The California Department of Technology, the Department of Consumer Affairs, they all direct us in the AI solutions that we're allowed to take part in right now. The Microsoft Copilot being the kind of official state solution right now, and there's a version called Copilot Chat, which is kind of sandboxed environment that prevents any sort of data leakage or things like that. There's also an enhanced version of Copilot that is kind of being evaluated right now by a lot of state agencies. While a lot of my programmers are very proficient in using AI and stuff like that, I admittedly have not used it for any more than simple summarizations of things and stuff like that, the kind of efficiency tools that we're all using it for. We've heard a lot of great presentations like from Mr. Myers and other people too, with these ideas of hopefully someday it helping reviewing complaints and things like that. I think we're, still a long way away from doing that, especially as it, keeps evolving and things like that. But basically the California Department of Technology dictates that any project we want to even start with any sort of generative AI capabilities and things like that needs special approvals before you even start reaching out to look to vendors and solutions and things like that. So while I have no doubt we'll get there someday, it's in its infancy. The state's always kind of a little
Right, fair enough.
slow to adapt the new technologies, but we're
Right, fair enough.
we're keeping up on it
Yeah.
and watching it closely.
So last thing, I know I said it was the last thing, one more thing. So is there a promotion plan to inform the public once this goes live? I would hope that you'd be doing a lot of, getting the word out that you can now use this online tool.
The complaint tracking system?
Yeah.
Yes. So
Thank you.
it will be a soft launch initially with information on our website. But the official launch, I guess, after the soft launch, everything's up and running, will be essentially when you submit your complaint online, if you provide an email address, which will be a requirement for using the complaint tracking system for the multi-factor authentication portion of it. So you will have to submit your complaint with an email. It doesn't matter if you submit it on paper or electronically, as long as you have an email address on there. Right at the time of the submission of your complaint, you'll get an email from the Breeze system basically letting you know, we've received your complaint, here's the complaint number. And from that point forward, you'll be able to access the system using your email and that complaint number. It sends you a code and then you can log into the system. So Yeah, while I expect there to be a lot of advertisements on our website and things like that, the main way people will know of its availability is that they'll receive that notification right when they submit their complaint, so they know point forward they can look it up in the system.
I think you should celebrate this. I think it's
Oh,
something that
we're
the
gonna party.
consumers have probably wanted for a really long time, which is why I'm suggesting that there be sort of a little launch kind of.
We definitely
communications
will.
program.
To go back on the history of it, I mean, we started having those initial internal planning meetings and things like that in 2022. We had to go through a formal project approval life cycle. We held these interested parties meetings, full documentation. The actual coding of it took my developer, a very talented developer, 6 months, and we've been testing it for that long and tweaking configurations and things like that. But what we planned for release 1 wasn't technologically even difficult. It was the first time we'd set up a lot of the stuff, but we knew by proof of concept we could do it all. It's just been marching towards this finish line. And so when we get release 1 done, we'll celebrate that. But like we said, we have a list of items that we're excited to add on too. So those release 2 enhancements we hope to start right after it. But yeah, we will definitely spend a lot of time analyzing those first months of usage and feedback we get from people and things like that. But we'll be very excited to launch. You'll be the first to know.
Okay, thank you.
Dr. Tsai.
Thank you. I have a question and comment for each one of our presenters. First, Sean, I think for the iOS 17 update, is there going to be the wallet card that I was mentioning? Because right now I sort of take a picture of the QR code, save it in my photo album, so if anybody needs it, I can print it out for them.
iOS 26 updates, or we're bringing it all the way up to the most current one. I'd tell you to download the PDF and keep the PDF, and you can forward that around. It's a separate project.
I see.
The mobile, the wallet, electronic version of it will be a separate project. That'll be an update and enhancement to the print yourself pocket, so you can just say add to mobile wallet instead of saving that PDF off. That's still on our to-do list. I know there's always look to exec for our project priorities and things like that. That's a one we'd love to do, and we'll be getting to it soon.
Thank you. And for Doug, I noticed that in terms of applications received and license issued over the 4-year period, it's on a downward trend. Is that sort of a blip, sort of a ditch in the road, or is that a trend? Because as we all know, the forecast is there's going to be a physician shortage by year 2030, or is that already upon us?
So you're referring to the physician surgeon's license?
Right, and the applications received and the license issued, they're sort of on a slowly downward trend. And is that, obviously we only have 4-year data. If it's over 10-year, maybe this. So what is your analysis of the situation?
So looking at the 4-year period, I know that there was a lot of changes in 2022 that really affected the physician surgeon licenses and the PTL licenses, where there became a huge backlog. And so if you look at like fiscal year 23, 24, the numbers spike.
Right.
So I think a lot of those numbers were from the prior fiscal year. I think what you're seeing now is the actual normal. I think 2023, 2024 is a bit of an anomaly.
Okay.
Because there's a lot of changes.
Thank you. And lastly, Charlene, I applaud, because I think Dr. Yip asked for wanting to know like how many total licensees are on probation every year, and having that number actually, lets us know what the percentage of licensees on probation compared to the total number, so that we have some sense of it. So thank you.
Sure.
Other questions, comments? Mr. Watkins?
Enforcement observations. So I presented the document just to summarize. We new board members, we felt we want high-level numbers as to how the enforcement unit is actually doing. So what I've done is I took the last 5 years, and this is the result. And Anybody can verify these numbers. All of these numbers are from the annual reports from 2020 to 2025. You can chat GPT it, it will all check out. And the spirit in which I do this is because I believe these are the real high level numbers that will actually move the needle. And I believe, no, I know we're on the wrong trajectory as of now. And let me just explain. So since 2020, the complaints have stayed steady around 9.5 to 10,000 complaints, right? But but what has happened is permanent removals, that is revocations and surrenders, have decreased by 46%. A whopping 40, that's almost 50%. The accusations that we file have gone down to 38% since 2020 to now, even though the complaint numbers are pretty steady. And the total discipline that the board imposes have decreased by 32%. But here's the deal, on the probation violations, that number has skyrocketed by 57% over the last five years. So what it begs the question from our point of view, and this is for the board to discuss and to decide, is what are we going to do about it? Because if we traject like this right now, and so I looked at those numbers and I said, okay, TJ, you know, I'm always bringing statistics because I want to, there's always statistics that actually move the needle, that show you exactly what's going on. This is the statistics that shows us exactly what is going on. And this points to somewhere in the system, if our labor, you know, like our staffing rate has stayed constant, so nothing happened there. The complaint stays constant, so nothing happened there. So something else is happening in the system, in decision-making, somewhere in the process, somewhere. I don't know. And I'm just curious, and this is for the board also to decide. You can go look at that chart that I gave to the board and just look for yourself, because those are the numbers that I think is more concerning, because they're on a trajectory downwards. And so I just ask that the board really consider, you know, like looking at those numbers and setting kind of, if we do the strategic plan in 2027, that these numbers take the front line, because it's important for public protection. Because right now, this looks like we're not protecting the public. We're going in a different direction. And I don't want to be inflammatory. I want this to be cooperative. Like we can actually see that there's some real issues here that I'm highlighting. And that's just the spirit of it. But, you know, I know you knew Ms. Arlene, and I like the fact that you come with a real positive energy. So thank you.
Additional comments, questions, Mr. Portillo?
I was just curious, do we know why like some of the enforcement actions are down?
I can't speak to the last 5 years. I mean, yes, you're right. The complaint numbers have been consistent, but I think what you also have to factor in is what are those complaints? Are they within our jurisdiction? We can receive 10,000, but not all of those are going to be within the board's jurisdiction. Then there's going to be anonymous. There's going to be people who don't respond to our requests. You know, there are roadblocks in the complaint process, and we do our best to utilize the resources we have to gather the information we need to move things along. At the end of the day, as far as actions taken, that's the burden of proof. We have to meet that. We have to, you know, establish by clear and convincing evidence that we've met that burden of proof. So I haven't seen your document. I'm sorry, so I can't really speak to it. But, you know, on behalf of myself and the enforcement team and our leadership, we are all interested in consumer protection. We're all consumers ourselves. And, you know, many of us have had our own tragedies in our own families. So It's not anything we take lightly, and we do everything within the policies, procedures, that and regulations that we're required to, and are always looking at other avenues and legislation changes that might be able to assist us to further that.
Additional comment, Dr. Mahmood?
Yes. So, yeah, I appreciate you looking at those numbers, TJ, and I thank you so much. I think your response is what I was going to say exactly. It doesn't have to be mathematically that complaints are that much and the execution will be this percentage. If you come to that point, that means you're trying to prove some point. If you look at the complaints with due diligence and with the merit, and if you're missing somebody, there's a problem. And all the cases come through us. But I think we cannot make a standard. This year there are 10,000 complaints and 200 people were revoked. And next year there are 10,000 complaints and 150 people were revoked. What's wrong? Or next year 250. You really cannot take that kind of percentage because you don't know what the level of complaints are, what the egregious complaints are. There are some people who have some just grievance with their colleague doctor or patient and kind of stuff. But obviously we should hold to our best standard possible for the protection of customer, protection of consumers and Californians. But I think just making that standard, this percentage of doctors should be definitely disciplined because we got this number of complaints. That is not really the purpose of this board. Our purpose is not to miss anything, and anybody who has done something wrong would be disciplined and watched and monitored and then rehabilitated or whatever. But I would think that we can go on complaint 1 or 2 or 3 years basis. I would request Madam President to consider maybe make a small subcommittee and go on those 5 years. And if you think something has gone wrong, we can correct that. But making a rule on that thing that this percentage of people have to be executed or have to be prosecuted, that is, I think, not a right message to the whole community. Thank you.
Additional comments or questions?
Yeah, I just want to clarify. That's not what I'm saying. I'm saying there is some policy shifts that has happened in the last 5 years. There's some policy shifts, whether it's internal or external, and this does not involve whether cases are designated to other boards or all of that. All of that, these numbers are equal. I can run these numbers 20 years and it will still stay consistent. Statistics tells you what is the system's failures in the system. And you, if you are open to it, you can articulate it. Let me tell you what some of my possible explanations could be. In the absence of that, there was no staffing changes and there wasn't a 40% drop in complaints suddenly. But there are these huge numbers of reductions in across the board for the last 5 years, but more so in the last 3 years. In the last 3 years, it actually became very evident that something has shifted. So some of those things could possibly be, this is for investigation, for exploration, is that a higher case threshold has been set. Somehow they became more like, hey, we're not gonna look into these cases anymore. That could happen. That is the plausible explanation for this. We can say, okay, there's greater diversion to probation or non-disciplinary actions, maybe pre-accusation PLRs, maybe citation, I don't know. But what I can say is that the probationary numbers also follow this trend. They've also reduced. And so I'm not talking about targets. I'm talking about allowing the numbers to tell us what is happening within the system. This is how systems analysis is done. Sean will know that. This is how we fix things. We don't fix things by just procedurally trying to, patch this and patch this. We fix it strategically. I'm giving a high-level perspective on the problem because this trajectory is going the other way. That's all I'm saying. I'm not saying set numbers or targets for that. I'm saying let's look at what has shifted that has moved these numbers away in that downward trend. That's all I'm saying. Nothing else. I'm not trying to radicalize or anything crazy. Okay.
Yeah, I guess I'd just like to add, because I think that trends analysis is important. It is the type of analysis we often see either in our sunset report or in the annual report that the board produces, right? As we look at, I mean, whether something was caused by staffing. I guess I want to amplify the point that Dr. Mahmood is making, which is having a target or some sort of quota for how many physicians should be disciplined, in my opinion, or, you know, how many should be on probation in a given year. I was really sort of misses the point about what we're all about. You know, and I don't want us to jump to the conclusion that the numbers are telling us that either the enforcement program is not working or that the enforcement firmness is somehow softened, because I think to the point Mr. Watkins was just making, the data could be telling us other things. There are a lot of things that have happened in the last 5 years, including that in 2026, we're now 6 years away from the onset of the COVID-19 pandemic, right? So trends in terms of what the case mix has looked like have certainly changed in 2026 from what they looked like in 2021 or 2022. You know, it could be the case that with respect to the probation violations, that we're actually seeing a physician health and wellness program, because a lot of the people that are on probation for substance abuse monitoring, right? And maybe we should dig in and really try to find out what that's all about. Frankly, the bill, as you all know, we'll talk about a little later today, the board has a program intended to address physician health and wellness issues as well. Could be because of improved conduct. I'm not convinced that's the case, but that certainly could be something that's out there. But again, there could be lots of reasons, and I don't want us to jump to the conclusion that it's because there's something wrong with the enforcement program. I do want to, acknowledge that looking for those trends and making sure we're on top of those and staying nimble as a board, rather than waiting for the trends to identify themselves and then, pivoting after the fact, I think is very, 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 very important. Dr. Yip, your hand was up.
I was going to say what you say, so you already said it.
Oh, perfect.
Seriously, I think the nice thing is you can see all the board members engaged, and all the board members one goal is to make the public safe and will do a better job. And TJ's kind of like ring the bell, and all the board members. I'm actually impressed by the 2 new board members. They really make good comments, and so the homework is to watch the last meeting. There's a pretty good analysis and bring the data. So that would be great to go back and watch it, and then from there we can train and we can make more suggestions how to improve and more transparent too. Thank you.
Are there any other questions or comments from board members? Ms. Holmes?
Sorry. So it's sort of like you're trying to do some root cause analysis, I think, is what I'm hearing you say, Mr. Watkins. And I don't, just putting the numbers up doesn't help us do that. So, I mean, it helps you begin a dialogue around that. And so I don't know what a next step would be. And that's sort of my question at this point is, well, is this just for information and we move on and we continue our work, or are we going to do something with this?
And that's good. And I'm not doing a roots analysis. I'm doing a systems analysis because I'm trying to understand, right? So if certain numbers stays the same, that means nothing has shifted. But now the major metrics are all trending downwards. That means somewhere on a policy level, something has shifted. Something in our behavior has shifted. This is not an anomaly, it's not 1 year, it's actually 5 years. So it is keep trending along that line. So somewhere along the line, a decision or something was happening in the system that changed the trajectory. I don't know what that is. And there is no thing that is going to fix it except identifying what are all the elements that is present in that decision-making process. So as for the next step is to analyze that whole process, because this points to, if I'm looking at, just take one line. If I'm taking that probation violations is up by 57%, then that points more to how we write stipulations. how we make those decisions, because what it is saying is that the stipulation that we are writing, the doctors are set up to fail that stipulation, or something in that calculation is off. That's what that's saying. A 50% increase in doctors failing probation is significant. All these numbers are significant. And like I said, they are not single year numbers. They are showing you a trend. If we take it back to the previous, if I pull it out 10 years, I would see the same trend. If I pull it back 15, I've already done it. So that's why I know. But today was just to introduce a conversation into it so that everybody can have top of mind that we do have real concerns about what is happening in the process. And this is how you judge it. You look at the public that is affected by our decisions. And you say they are screaming and they are doing everything. They don't even want to engage with the board. And how do we fix that? You see, there was somewhere along the line a system, a part of something did not work. And I don't want to take the responsibility of individually taking that on. No, I just want to point it out, and we can decide as a body if it's important enough for us to take on, or if it's not. The numbers always tell the story, no matter what industry you are in. Thank you.
I think Ms. Holmes sort of gets your point about next steps. I mean, we're going to hear a discussion in agenda item 7 of a deep dive on one issue. And I think it's going to expose some of the complexity of, trying to understand what's happening in our data and how we can solve these problems. It took us a long time, a really long time. I know more time than the public would have liked us to get even the data for agenda item 7. And I think you're going to hear again about some of that complexity when we get there, because trying to understand any of these individual issues is shockingly difficult. I guess just from a data perspective in terms of what we collect and how we analyze it. And I would encourage us as a group to not jump to the conclusion that it is always something in our process that is the challenge or the flaw or what have you. It is equally as plausible. What I talked about in terms of what's causing probation violations, that we potentially have a severe physician health and wellness crisis or a broader mental health and wellness crisis in our country writ large that's causing those violations. Not that the way we wrote the stipulation to require the monitoring is necessarily causing that. So we should get to that analysis. We should understand it, but we shouldn't vilify our staff and our teams and our process in the process of trying to understand that data, because the fact of the matter is that, everyone that I've ever worked with at the Medical Board of California is singularly focused and is mission driven on protecting patients and consumers in California. So if there are no further comments here, I suspect there are going to be some public comments from the room and online. I'd like to move on to that. Mr. Watkins, can we move on to the public comments, please? Thanks. Public comments from those in the room.
Good afternoon. My name is Michelle Montserrat Ramos, and I'm with Consumer Watchdog. To begin with, the complaint tracking notification system. For the new board members, that project actually was an idea that came from the public. Consumer advocates brought the issue to the board and pushed the issue through, and it wouldn't be here today without the support of Dr. Yip. Dr. Yip supported the project, and it's one of the occasions where the board collaborated with the public. Secondly, regarding the enforcement process, I work directly with families. We work directly with families. And unfortunately, we've had to actually organize campaigns in communities to educate the public about the board, to educate the public about the issues in that community, because there were repeat offender doctors that were harming families for 32 years. And those doctors kept getting placed on probation, or nothing occurred with these complaints. So there's no way that we could possibly work with 5,000 people. It's hard to work with 75, 80 families. But that is what is happening in the communities. That is what's happening with these families. As the board president said, you'll hear from some of them on agenda item 7. But that is the extent we've had to take in order to get some type of accountability for these families with repeat offender doctors. Thank you.
Thank you for your public comment. Are there other comments in the room? All right, Sean, if we could open it up on WebEx.
Yes, if you'd like to make a public comment here on agenda item number 6, please do so by raising your hand. If you'd like to make a public comment, you can also just type something in that Q&A window. You can't find the raising your hand, but please don't bother in typing your entire question. Just I'd like to make a public comment is enough to get you called upon, and you can ask it verbally. First here we have Eric Andrist. Eric, you should be receiving that prompt.
Dr. Mahmood, you're taking TJ's numbers to task for being mathematical, but not Reggie's. They're both mathematical, but TJ is proving that Reggie's numbers are skewed to make the board look better, and that's important. We've been trying to get this board audited to no avail for decades. Why is that? To the newbie members of the board, stand on your own 2 feet. Don't blindly follow the manipulative rantings of Christina Lawson, who clearly has a CMA-induced bias she wants to amplify to the point of the CMA. To only go by Reggie's numbers is giving the wrong impression she's talking about. And of course, she has to shamefully plug her bill like an ambulance chaser. Dr. Yip, it is not the board's goal to make the public safe. That's why the public hates you all. Much of the information you've been given is incorrect and easily verified using the AI we just heard about, as I have done comparing TJ's numbers to Reggie's. Put both versions in AI and let it tell you the truth, so follow along. And for the record, every figure I'm about to cite comes directly from the Medical Board of California's published annual reports. TJ is not just pulling them out of the air, and they cover 2021 through 2025. These numbers are not estimates. They are the board's own data. Read across years where noted, added together. Starting with complaints, in 2021, the board reported 10,103 complaints against physicians and surgeons. By 2025, it reported 9,707. That is essentially flat volume over 5 years, not a collapse in complaints. Second, serious discipline. Using the board's administrative outcome tables and counting permanent removals such as revocations and surrenders, the board imposed 154 permanent removals in 2021. By 2025, that number was 84. That is a 46% decline in permanent removals, even though complaints stayed roughly the same. Looking at all formal disciplinary outcomes, the board reported 451 outcomes in 2021 and 308 in 2025. However, you define the roll-up, that is roughly a 1/3 drop in discipline during a period when complaint volume did not drop. Accusations show the same pattern. In 2021, the board filed 383 accusations. By 2025, it filed 239. That is a 38% reduction. If you look at this board as a conversion rate from complaint to accusation, the board's own numbers show that about 3.8% of complaints become accusations in 2021 versus 2.5% in 2025. That is a roughly 35% decline in the likelihood that a complaint advances to formal accusations. At the same time, probation violations increased. In 2021, there were 35 probation violation cases resulting in board action. By 2025, there were 55, a 57% increase. So using only the board's annual reports, the picture is clear. Complaints stay stable, but permanent removals, total disciplinary outcomes, and accusations all declined significantly, while probation violations increased.
Please conclude.
I'm done.
Thank you very much. Next up here, we have Marion Hollingsworth. You should be receiving that prompt.
Okay, can you hear me?
Ken, Marion, please go ahead.
Okay. Okay, thank you so much. My name is Marion Hollingsworth, patient safety advocate. I support Mr. Watkins with his proof that the medical board is getting more lenient with disciplinary actions. And I thank him for being so determined to find out the truth of how the board really treats doctor investigations. I read every accusation and decision that the board posts, and I have noticed on my own a distinct pattern of increased leniency. It seems like you board members completely disregard your own disciplinary guidelines, and I encourage the new members to read them over before you make decisions on doctor disciplines. I can even name cases that have been completely lenient, like the doctor who literally worked for a board member at the time he was arrested for a DUI, and that DUI was a .29. According to the disciplinary guidelines, he should have been put on probation for at least 5 years and had the required drug testing, but you just gave him a reprimand. The decision said he hadn't had a drink since his arrest. Excuse me. But how would you even know if he had a drink if you didn't require testing? Did his association with a board member make a difference? We can only speculate. There was also a big-name political doctor who botched an epidural a few years ago, causing the patients to code right before a C-section. Her life was saved, but she now needs 24/7 care now. I happened to trip over this case online after a huge lawsuit was settled, but you gave this doctor just a citation, which you should all know is not considered a reprimand, would not consider a discipline. Why only a citation? At the time of this decision, there were 5 CMA members on this board, and this doctor had a long history with the CMA in Sacramento. Again, just speculation on leniency. My point is, Mr. Watkins' numbers on leniency just prove that what we advocates have suspected for a long time. A 35% decline in complaints advancing to an accusation is dismal. You can't say you are protecting the public when you are protecting dangerous doctors. The public deserves better. I urge you all to take your jobs more seriously to uphold the purpose of the board, which protects consumers. And if you're going by what Ms. Lawson says about improved conduct by doctors, you should all read the last 6 months of disciplines that include a high number of DUIs, doctors under the influence at work, even in the OR, and sexual misconduct cases, many of which end up in easy probations. Thank you.
Thank you for your public comment. Next here we have Maria Barr Navarrete. You should be receiving that prompt.
My name is Maria Ibarra Navarrete. I am from San Jose. I'm a volunteer with Consumers Watchdog. How do you know what is more user-friendly for complainants if you do not ask the actual group that works directly with the public? We have expressed these concerns meeting after meeting with no response. We actually do work directly with complainant families, and we help them navigate through your incredibly difficult enforcement process. What are you doing when a family sends you just an email to the board with the most basic information in the email with no written details of exactly what occurred to cause this complaint to be sent to you? We have personally spoken with families who sent an email to this board in the past and asked them what the board's response was. We were told this board never responded. We can specifically say that some of these complaints were about some of your repeat offender doctors that continue to harm family members, and family members continue to die. The question is why? Just as a board staff mentioned in continuing medical education audit enhancements, board staff expects the enhancement will make the process easier on licensees. We want the same for the families that send you guys the complaints. We want this board to look at them. We are your stakeholders. Thank you.
Thank you for your public comment. At this time, no additional requests are in queue.
Thanks, Sean. We'll bring it back to the board. Are there any further comments or questions from board members of our staff? Okay, seeing none, we will move on to agenda item 7, discussion on maternal mortality, data and outcomes. I think Ms. Smith, you didn't even move. You're sitting right there. All right.
Thank you. So this information is being provided in response to requests from patient advocates. And yes, it has been a request for some years, and we do thank them for their patience. The information reviewed they asked us to review maternal mortality data to provide a summary of the complaints received, the complaints that were referred for review by a medical consultant, complaints that were closed, complaints that were referred for investigation that may have been forwarded on to the Attorney General's office, what the outcomes of the complaints were, and the specialties of the licensees, and the closing dispositions, and whether the licensees had prior administrative action. So the statute, the Health and Safety Code, section 123635A, defines maternal mortality and maternal death. So we use that as our guide. We cast a very broad net to look for complaints, looking at all specialties. The specialties that we identified in my report, which would be licensed midwives, internal medicine, family medicine, emergency medicine, surgery, obstetrics, gynecology, neonatology, and perinatology. And from there, we did go through the data and look at the 3 fiscal years. I do want to make sure you all note that the closed data may include complaints that were received in a prior fiscal year. So perhaps they were closed in the 24-25, but they could have been received in the 2 years prior to that. So the data captured revealed the respondents were physicians either practicing the specialties of obstetrics, gynecology, internal medicine, emergency medicine, neonatology and perinatology, and then licensed midwives as well. So we broke the data down in 2 ways. We broke it down by complaints received, by their received date, and also by the complaints when they were closed, which fiscal year. So for the breakdown of the complaints received in fiscal years 22, 23, 23, 24, and 24, 25, we found that there were 24 complaints received. We did find that 3 of the licensees identified had prior administrative action. 15 complaints were referred for a review by a medical consultant. 18 complaints were closed. 5 complaints currently remain open. 8 were referred for investigation, and 5 were referred to the Attorney General's office. There were 2 accusations filed, and those resulted in 1 surrender and 1 run revocation. And as I mentioned, the complaints closed by those same fiscal years. It could have been a complaint that was received in a prior fiscal year. So looking at the complaints closed in those same 3 fiscal years, we found that 2 licensees had prior administrative action. 14 were referred for medical consultant review. 6 were referred for investigation. 4 were referred to the Attorney General's office, and 4 accusations were filed, resulting in 1 surrender and 2 licensees being placed on probation. Some of the roadblocks in looking at these complaints, some things that could cause closures could be lack of cooperation, not receiving responses from consumers for authorizations, things of that nature, anonymous complaints that don't provide us any complainant contact information, patient information, any identifying information that could help us to utilize resources available to try to proceed further. And also unfortunately, if we don't meet the burden of proof, the clear and convincing evidence, we may not be able to proceed further. So we did find that the complaints were submitted via a variety of sources. So, anonymous, we have mandatory reporting for the midwives and the physicians and surgeons, family members, patient advocates, licensees, everybody was captured in that data. And those were the findings. The board packet does provide the chart that gives the breakdown. And I'm happy to answer any questions.
Thank you, Ms. Smith. Are there any questions or comments from board members about this data? Mr. Portillo.
I saw on the breakdown of the findings related to the 24 complaints received, 5 were referred to the Attorney General's actions, 2 accusations filed. Does that mean that the AG declined to file action on three other
They
cases?
could have been, or they could have been consolidated. So on the chart, the Excel spreadsheet, it does mention that the total number of closed includes those that were closed insufficient evidence or inadequate evidence, past statute, or accusations were dismissed, or they were consolidated with another case.
Additional comments, questions? I actually think that chart, Ms. Smith, to your point, is instructive because it talks about the reasons why these complaints were closed, and insufficient evidence in at least 1 year. Yeah, or, 2 cases. Anyway, there's lots of reasons why these are closed. So digging into that data is helpful. And that's where we get that trends analysis, what's actually happening and what's going on.
Right. And if I can correct
process.
myself, it does exclude cases closed because they were consolidated with another case. Excuse me, I did misspeak.
Thanks. Other questions, comments from board members? Let's open it up to the public, please. I'm sorry, did I miss somebody? I'm sorry. I looked over there twice also. I'm sorry.
Thank you so
Dr. Ayala Rodriguez.
Thank you so much. No, and I really appreciate for the report because I know that it was like requested also like last meeting. So thank you so much for providing something. I think that I was like thinking about it. I was thinking about maternal infant mortality rates, California, different places, things like that. And I'm like, definitely this provides me more information towards one of the many stakeholders that are like part of that big bucket. Because like, for example, yes, we look at this from the licensee perspective, and that's the main area, right? Like that we look into it. Then I look at maternal mortality, rates, and I'm like, well, there's still questions that obviously maybe we cannot answer because there's other stakeholders in the game, right? Like the public health department, like the hospitals, like other shortages and things like that. Because like what we're doing is like, is there any finding that we're seeing in our licensees? Is there any action that we could have taken? Is there any finding among the licensees that maybe we have to handle differently? And you're sharing your findings. But there's, I think that the other part of the conversation, right? That it's like, okay, and together as a group of stakeholders supporting California, what can we do? Right? Because according to us, this is the level of accountability that we have. This is what we can do or cannot do from our point. But as a shared problem, how can we tackle it and what can we do better? So I think that maybe later on in the future, like it would be important to get that feedback from the other stakeholders, right? I know, for example, even the Surgeon General, for example, went to Kern County and like talk about like maternal mortality. They're doing also some initiatives for improving like maternal mortality and things like that. So I think that it would be important also to understand what's the landscape, what are the stakeholders, and what's the intervention that each of us can do to have a better California. Yeah, thank you.
Thank you. We double and triple check. Any more comments or questions? All right, seeing none, let's open it up for public comment from those in the room.
Good afternoon. I'm Michelle Montserrat Ramos, and I'm a consumer watchdog. Just to say that this is, I know it was mentioned a comment earlier, but this is actually an agenda item that the public requested. So in January 2020, I helped the first maternal negligence family with media relations. Once the news clips hit, my phone began to ring with calls from mothers, grandmothers, and a father, all with heartbreaking stories. Many of these families had something in common. Their tragedies were linked to the same physician, all of them repeat offenders. One with a long history with this board that she had allowed to harm mothers and babies for 32 years. One of the grandmothers had already filed a complaint on behalf of her 23-year-old granddaughter, Celeste. Celeste's birthday was the other day. Her children have gone motherless for 10 years now. Celeste had a problem-free pregnancy and delivery. The problem was that her doctor could not wait for her placenta to dispel. He reached his hand in and tried to yank out her placenta. He then used forceps and then used his hands again. Her family could hear her screams down the hallway. The doctor perforated her cervix and uterus and watched her bleed to death, leaving behind her newborn baby and other children. The doctor was the 32-year repeat offender. The outcome of the complaint? Probation again. The doctor was given a lifeline to continue to harm other mothers. Celeste was not. I had other families ready to file complaints, and I knew that we could not continue to do the same thing. So I organized a campaign in the Central Valley to bring attention to maternal mortality crises. I met many families who had also lost mothers and babies due to the incompetence of the same licensees. Some of these families said that they had filed complaints. They sent an email to this board, but board staff never responded. Had these complaints been addressed then with disciplinary actions, you could have saved lives. In 2023, we asked for you to hold your meeting in Bakersfield, and we requested a maternal mortality report. It took 2.5 years to receive this data. This is a start, but I have to say, incredibly disappointing for our families. They have come before you many for 6 years now, and this is what was provided. These are the same families that fought for your fee increase. These are the same families that advocated for cost recovery that has benefited your financial condition. If you look at the materials, it states that this board received 24 complaints during a 3-year time period. I can tell you that I have personally spoken with that many families. In your complaints received stats, you state that you have 3 licensees with prior administrative action, but your closed complaints list only 2 doctors. What happened to the 3rd doctor? Most importantly, what were the administrative actions for? Staff stated that they felt the administrative actions were not linked to the complaints listed here. When I asked how, I was not really given an answer. We want to know if there are patterns here, patterns that the public can educate themselves on, and that staff can see so board staff can better recognize the patterns of maternal negligence. We're asking you to contract with the California Department of Public Health and obtain maternal mortality data from them. We're asking you to replicate the opioids project from 2015, but for maternal mortality. Our families are weary of hearing you say that your priority is consumer protection. They want you to show them. Thank you.
Thank you for public comment. Are there other commenters in the room? All right, Sean, let's open it up online.
Yes, if you'd like to make a public comment for agenda item 7, please do so by raising your hand or just typing anything in that Q&A window, and we'll get you called upon. First up here, we have Kimberly Turbin. Kimberly should be receiving a prompt.
Can you hear me?
Okay, Kimberly, please go ahead.
Okay. Hi, my name is Kimberly Turbin, and I am from Reseda and a volunteer with Consumer Watchdog. I was harmed 12 years ago while giving birth to my son. My OB walked into the room with episiotomy scissors in his hand. I pleaded with him not to cut me, but he yelled at me, and he told me that he was the doctor. He told me if I didn't like it, I could go have my baby on the floor or go have my baby in Kentucky. There was no medical reason for the episiotomy. He then began to slice me 12 times from the top of my vagina all the way down to my bottom. I couldn't sit for months. I was in agonizing pain. This pain and harm continues today. While I was delivering my baby, the nurses told me that my son was going to be born with a sombrero since it happened to be Cinco de Mayo, May 5th. I have endured pain for 12 years. I find myself in the ER often having to deal with long-term complications because of what he did to me and what his actions brought. Thankfully, I survived and my son survived. I have spent much of my time advocating for medical battery and in support of curbing maternal mortality crisis. I also was at the Bakersfield Medical Board meeting. We asked for this data, and we waited 2.5 years for this data. Yet, this is what we receive. We can do more. We have to do more. We are asking you to request that staff enter a contract with the California Department of Public Health to obtain maternal mortality and infant mortality data. We are asking you to request staff to initiate a project similar to the 2015 opioids project for the maternal mortality. Thank you for your time.
Thank you for your public comment. Next here we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, you can just hear me, I assume, Sean.
We can, Rob. Please go ahead.
I was one of the people that blew up and made a huge scene at your meeting in San Diego, whenever that was. And this was one of the issues. And I remember exactly what I said because it had been so ridiculously long. I said, would you people either give these women these people the data they want or tell them you don't have it? It got to be ridiculous. So I guess that, now that I'm just looking at it for the first time here, I'm just kind of wondering, are these kids teenagers now? And the data, I have not analyzed it, so I'm speaking out of turn here. It looks absolutely pathetic. And you're talking about this gaslighting, telling us how great this data is and how much analysis it took. That is pathetic. It's like 8 data points. I know you have all, I assume you have all seen the John Oliver program he did on medical boards. Highly critical of California, and you guys deserved it. But what caught me on that show was the number of medical deaths by errors. And he says that in the United States, it's 250,000 people a year. Now, that number is controversial. Some people do believe that's high. That's from mistakes. But that, you're supposed to always, nobody ever talks about this. You are also supposed to be providing medical quality assurance, and you don't do that. And just getting those numbers back, if you had real good data on that, which you could have if you wanted to, if you were in a competent board, just getting that number down, I think TJ said moving the needle a little bit, then you would be really saving lives. The way you're working now, nobody in government ever gets in trouble for what they don't do that should be done. I think they should, but we're looking at, you might be responsible for a mass casualty event. A lot of people might have died from your incompetence and lack of work. So I just want you to kind of reflect a little bit. You, again, get some money. You are an unpaid, all volunteer for only 15 people who only meet once every 3 months. And you're responsible for regulating 150,000 physicians in California, providing medical policy, judging them, lobbying the state assembly, and much more than that. And now you want to start regulating AI. It is absurd. You guys just have a little bit of self-awareness. Have what alcoholics call a moment of clarity. Just now and again, think of what you're doing and who you are. Start keeping time cards on how much time you spend, including emotional energy you spend. We need your data because you are extremely dysfunctional to the point of being dangerous. Thank you for listening.
Thank you for your public comment. Next here we have Eric Andrist. Eric, you should be receiving that prompt.
The thing that this board never wants to address is why these cases are really being closed. I appreciate this study, but can we really trust these numbers? TJ has just shown us we can't. Sure, you can come up with all kinds of Excel sheet labels and anyone just accepts them because it's too hard and too uncomfortable to question them and expect a scolding by Christina. Insufficient evidence is a ridiculous term. We have evidence of cases that were closed by your so-called experts that went on later to be reopened solely because the family won a lawsuit against the doctor. I'd like to tell you why the public can't trust the reports like the one just given. For the new members, I filed a complaint against the doctor in my disabled sister's case. For the new members, she went into the hospital with a strangulated bowel. The doctors allowed her to writhe in pain for 15 hours before finally giving her Dilaudid for pain, a drug 7 times stronger than morphine. But shortly before they gave it to her, they had her drink a radioactive beverage for a CT scan. During the scan, because she was passed out from the Dilaudid, she aspirated the radioactive drug into her lungs, causing pulmonary edema, and sent her into cardiac arrest. The staff thinking she was a DNR, a do not resuscitate, solely because she was mentally challenged, stood around doing nothing to revive her. When they realized they were wrong, they called a code blue and did revive her 17 minutes later, but it was too late. She was brain dead. I filed a medical board complaint and nursing board complaints. The nursing board disciplined the 2 nurses. But guess what this board did? They closed the case, saying it wasn't beyond the standard of care. This is the board you're representing, and they're lying to you about why cases are being closed. So who, aside from TJ, is really going to step up for patient safety and stop kissing the board's ass for your political careers and padding your resumes? Christina's dad was a doctor who sounds like he did good work. I think he's rolling over in his grave the way she behaves now and sticks up for the doctors and the CMA. Thank you.
Thank you for your public comment. Next here we have Dylan Izaseta. Should be receiving a prompt. Hey Dylan, I'm not seeing your line opening here. I'll circle back. Next request here is Monique Hines. I think you should be receiving that prompt.
Hello, I am Monique Himes. I am from Bakersfield and a volunteer with Consumer Watchdog. I was present at the Bakersfield Medical Board meeting and was one of the grandmothers who asked for you to provide us with a report on maternal mortality. We have done our best to bring issues before this board to try and address accountability or lack of accountability for these many maternal and infant deaths in our community. We waited 2.5 years for this report and it was a disappointment. You have complaints closed due to insufficient evidence and inadequate evidence. What is the difference? Aren't they the same? Why is there not information listed as to why the complaint was closed due to insufficient evidence and why the complaint was closed due to inadequate evidence? Isn't it important to know why you are closing maternal and infant death and long-term harm complaints? The data does not disclose names or complaint numbers, so you would only be revealing data with no identifiers. My grandson, Malachi DeLeon, was harmed by 3 doctors. He would be 7 this year had he survived. He was harmed, by 2 OBs who ignored his mother's clear preeclampsia complications. And then he was tragically harmed on all his own by a perinatal specialist. We filed a complaint against the perinatal specialist, the specialist who wasted an hour and a half trying to get my grandson into a study instead of immediately airlifting him to a hospital for a higher level of care because he knew that the hospital did not have the resources to sustain him. This is the same doctor who had the emergency team from the forwarding hospital stand around for hours while he made mistake after mistake. Where is my grandson's closed complaint in this data? It should be there. We were never told why my grandson's complaint was closed, why his death did not matter to you. We need change. I cannot continue to watch other mothers and babies die in our community with no real effort to save our families' lives. We are now asking you to require the board staff to obtain maternal and infant mortality data from the California Department of Public Health. We need real data. We are asking you to initiate a project similar to the 2015 opioid project for maternal mortality. I think we can agree that too many mothers and babies have lost their lives. A CDPH maternal and infant mortality data project will give us some answers that we need to move forward. Thank you.
Thank you for your public comment. I saw Dylan unmute during that public comment here, so we're going to go back to Dylan to see if they still want to make a public comment. Dylan, if you can unmute again.
Hi, can you hear me now?
Yes, we can, Dylan. Please go ahead.
Okay, thank you so much. Good afternoon. I am Dylan Izaseta. I am from Reno Valley, and I'm a volunteer with Consumer Watchdog. I was set to give birth to my beautiful baby girl Yet by the time I arrived at the hospital, my baby was already gone. I will never forget the day for as long as I live. It is the pain that I carry in my heart to this day. I had to go home and explain to my daughter why her baby sister did not come home with us. Her death was entirely preventable. All my doctor had to do was initiate the order that he agreed to. If he conducted the necessary testing, he would have seen that my baby needed to be taken out immediately to save her. But he did not follow his own orders. Now my baby girl is gone. I saw your data. It was incredibly disappointing. I want to know why the complaints were closed. I want to know what kind of issues the repeat offender doctors had. Did they misdiagnose the patient? Did they fail to follow protocols? Did they not provide necessary testing? Did they not send a high-risk patient to be overseen by a high-risk doctor? This information we need to know, and you should want to know too. Yes, my doctor was also a repeat offender. He is not the 32 repeat offender that some of my team members are referring to, but he is a repeat offender doctor. I am joining my fellow team members in requesting that you enter a contract with the California Public of Health to obtain maternal and infant mortality data. We are asking for a project similar to the 2015 opioids project. We need more information to achieve this real change. Thank you so much.
Thank you for your public comment. Next here we have Marion Hollingsworth. Should be receiving that prompt.
Okay, can you hear me?
We can, Marion. Please go ahead.
Okay, thank you. Good afternoon. This is Marion Hollingsworth, Patient Safety Advocate. First, I want to say that two board members commented on the the maternal mortality case, but there were 5 comments on the AI, so it kind of shows where the board is as far as what is more important. I have some questions for you regarding this maternal mortality report. The numbers strike me as being rather paltry at best, considering the number of actual deaths to maternal mortality in the California Surgeon General's 2024 report. Dr. Diana Ramos stated that a woman dies in the state every 5 days due to childbirth complications. That's 73 per year, or a potential of 219 for a 3-year period. I know you can only rely on complaints that you have received, but given the stats by the California Surgeon General, you would expect your complaint numbers should be much higher, especially with the 805 reports. It's also concerning that your accusation and decision numbers are not higher, considering that each one of these cases is a death. So we're not just talking numbers, we are talking dead mothers who will never go home to their families and never be able to raise their children. And according to Dr. Ramos, 80% of maternal deaths are preventable. So it seems to me that the medical board should have more work than what appears in your report. Maybe a little bit more of a deep dive, as you say. Also, when looking at the doctors you tally in this report, you have obstetricians, ER doctors, internists, and others, but you don't include anesthesiologists. I can name several egregious childbirth cases, including one where the anesthesiologist gave the mother digoxin in her epidural instead of the medication she was supposed to get. That error caused catastrophic brain damage, resulting in the young mother having to live the rest of her life in a care facility instead of being able to raise her children. There's another case where a high-profile anesthesiologist that I mentioned earlier gave an epidural too quickly. The subsequent lawsuit stated that the mother coded, and the OB was forced to frantically cut her open while the nurses gave her chest compressions. She's also living her life in a wheelchair. And the doctor, as I mentioned, was just given a $350 citation. But according to your report, you don't include things like that because you only include deaths. Considering all these cases, it might be helpful to include anesthesiologists in your maternal mortality numbers. And finally, your report addresses women who died in childbirth, but I think it would be more complete if you included egregious harm cases like I just described. There have been so many near-miss childbirth cases resulting in permanent harm to mothers. I think it's remiss not to include that. For example, there's an OBGYN in El Centro, a former CMA County president, by the way, who, according to documents, your own documents, mishandled a preeclampsia case so badly the woman had to be airlifted to San Diego for better treatment for her massive hemorrhaging. And your decision didn't include the final outcome of her. I urge you to go back to the drawing board to reinvestigate this issue more thoroughly and come back to us with a more comprehensive assessment of your handling of maternal harm. Thank you.
Thank you for your public comment. Next here we have Denise Johnson. Denise, you should be receiving a prompt.
Good afternoon, Madam Chair, members of the board. My name is Denise Johnson. I'm from Tracy and a volunteer with the Consumer Watchdog. I made the trip to Bakersfield for the Bakersfield Medical Board meeting to support my fellow advocates. It was a great meeting and we appreciated your willingness to hear everyone's voices and host the meeting in Bakersfield, dedicating an entire day to the vital issues of maternal health and maternal mortality. During the meeting, we requested a report with statistics on maternal mortality. The board agreed. We left the meeting with a renewed sense of hope, feeling that we had all reached the same page. Then we received this report. It was unbelievable to me when I read the board materials. The numbers don't tell us anything. We would like to know how many people these complaints affected. Are the 24 complaints linked to separate individuals, or do some of them involve both mother and baby? How many priors did the licensees have? Did they have one prior administrative action or 3? Did they have complaints filed against them that the board did not take prior action on? What were the reasons for the disciplinary actions? Understanding the reasons behind disciplinary actions is crucial. It unveils a significant narrative. There is a problem to repeat offender doctors, and it begs a vital question. Are these providers continuing to overlook troubling complications? Are they disregarding established protocols? We know that licensees have been placed on probation multiple times, despite their serious accountability in causing numerous deaths and long-lasting harm to mothers and babies. It's imperative that we acknowledge these troubling patterns. They truly exist. As members of the public, we aspire to shine a light on these issues, and we believe the board should seek to do the same. By recognizing these trends, you can empower board staff to navigate complaints more effectively and give board members the insight they need to ask the right questions during hearings. Together, we can take decisive actions to prevent further tragedies and protect the vulnerable lives at stake. We want change, and we need you to join us. We need your support to request board staff to conduct a project similar to the Impact 2015 opioids project. We ask you to obtain the maternal mortality data from the California Department of Public Health, extract the information relevant to our providers, and conduct outreach to our families. Together, we can derive into why bringing a child into this world in this state poses greater risk than it did for our mothers. This is a crucial opportunity to make a meaningful difference in the lives of our mothers and babies. Your encouragement in this vital case could help protect future generations and ensure a safer environment for childbirth. Thank you.
Thank you for your public comment. Next here we have Maria Ibarra Navarrete. You should be receiving that prompt.
Yes, my name is Maria Ibarra Navarrete. I am from San Jose and I volunteer with Consumers Watchdog. I had an opportunity to attend the Bakersfield Medical Board meeting in 2023, where I joined our team of advocates calling for comprehensive maternal mortality report. We waited 3 years for this report. This report lacks substance and fails to provide meaningful insight for the public and your board. It is astonishing that this board received just 24 complaints concerning maternal health and maternal mortality over the 3-year period. Out of these 24 complaints, only 15 warranted a referral to a medical consultant for review. What became of the 9 complainants that were not referred, and what reasons led to their exclusion from a review by a medical consultant? Out of the 24 complaints, the materials disclose that 18 complaints were closed. How many of the 18 complaints were closed or originated in a different year? And why were the 18 complaints closed? It is frustrating to respond to this lack of data. Along with our dedicated team, I have participated in these meetings for 4 years, showing our support on issues that matter most to you. During past sunset reviews, while the California Medical Association pushed to reduce your fee increase, we advocated for your financial well-being instead. Our commitment extended beyond mere support in meetings. We actively engage with legislators to promote not only your fee increase, but also essential cost recovery measures. Our advocacy has been instrumental in helping you rebuild from your financial distress. We understand that you need funding in order to review and investigate our complaints, but this data shows little effort in holding providers accountable. Now we ask for data, and you provide these families who have all endured the profound sorrow of tragic deaths, just like I have. With this limited information, we are trying our best to work with you, but we urgently need to see proactive response from your end. We request that you replicate the opioid project from 2015. This involves entering into a contract with the Department of Public Health to access vital maternal mortality data. Armed with this information, you have the opportunity to reach out to families, encourage them to voice their experiences, and file consumer complaints. If you can effectively tackle the issue of opioid overprescribing, we believe you can also make a significant impact in addressing the pressing maternal mortality crisis, especially in the Central Valley, where lives are at stake daily. Together, we can bring what a meaningful change, and we can save lives. Thank you.
Thank you for your public comment. Next here we have Tracy. Tracy, you should be receiving that prompt.
Hi, I'm Tracy Dominguez. I am from Bakersfield and a volunteer with Consumer Watchdog. You have no idea how hard it is to read this. I began my journey in advocacy 6 years ago following the death of my daughter, Demi. Demi was so excited to welcome her newborn son into the world. She took care of herself, but she noticed she was having complications and was scared. She tried to see her regular OB, but he wouldn't see her. Let's see it. Before her scheduled appointment. Waiting to protect her unborn son, Malachi, she went to the hospital to seek care, but the on-call doctor at the hospital failed her. She was admitted, but the on-call doctor never went to see her, never assessed her, never allowed her to be, and he allowed her to be discharged with no diagnosis. After her hospitalization, she went to see her OB for her scheduled appointment. She gave him her discharge paperwork and explained to her OB all of her symptoms. He ignored her, telling her the baby was fine. He sent her home and suggested that she just get a massage. Later that night, my daughter had a seizure in her bed and she died. My grandson was left to face post-mortem C-section. Unbelievable, my grandson received incredibly neglect care from the hospital and died 18 hours after his mother's death. After his birth. We have brought many issues to this board. We encouraged you to host your board meeting in Bakersfield, and we are glad that you did. Thank you. We asked for a maternal mortality report, and you gave us a disappointing one. Does this board close complaints with merit like the osteopathic board does? There may be one simple departure, and that there is not enough to go. There's not enough to go to the AG's office, but you keep it for 5 years. And can you add it to a prior significant evidence to a new complaint? I thought this board held on to complaints with potential moving them forward in the future with a new complaint. We cannot see that information on your data. We cannot see any usable information in your data. We are asking you, please, request the board staff to obtain the maternal mortality and infant mortality data with the California Department of Public Health. You did this something similar with the opiate project. We are asking you to please conduct the same project for maternal mortality. And also another mother died here in town and was harmed, and she lost her life. Thank you.
Thank you for your public comment. Next here we have Alex Dominguez. Alex should be receiving that prompt.
Hello?
Yes, Alex. Please
Oh,
go ahead.
okay. I'm ready. Good afternoon. My name is Alex Dominguez. I'm a resident of Bakersfield and a volunteer with Consumer Watchdog. I stand before you today not just as an advocate, but as a grieving brother and uncle. I'm here to give a voice to two members of my family who were silenced by gross maternal and infant negligence. My sister Demi Dominguez and my nephew Malachi De Leon. My sister was the picture of health. She was proactive, she had a personal trainer, and did everything right to prepare her for pregnancy. What she didn't know, what she couldn't have known, was that her own personal trainer had already been harmed the very same way by the same two doctors who would eventually be responsible for Demi and Malachi's deaths. When complications began, Demi knew something was wrong. She sought out answers, but instead of receiving care, she was met with indifference. Both of her doctors ignored her. When her OB refused to see her, she did exactly what we are told to do. She went to the hospital to protect herself and her unborn son. But the negligence followed her there. The doctor on call refused to see her in person, eventually instructing nurses to discharge her verbally with no diagnosis. Even at her final scheduled visit, Demi begged for help. She detailed her symptoms, but her OB dismissed her, telling her the baby was fine and even suggesting she just get a massage and lie down. But that very night, my sister suffered a seizure and passed away. The tragedy didn't end there. My nephew Malachi was subject to a post-mortem C-section and spent the final 18 hours of his short life enduring one negligent act after another. From specialists who couldn't accurately insert an umbilical catheter to a fatal 8-hour delay in transferring him to a higher level of care. The system failed him at every turn. Yet, despite this, the complaint against the specialist was closed by this board. We are here because we need answers. The current data is not providing them. Statistics don't capture the agony of a family torn apart by preventable errors. I'm asking this board to take immediate action. Request the comprehensive maternal mortality data from the California Department of Public Health. We need you to move forward with a dedicated project for maternal mortality, modeled after the 2015 opiate project. You have the authority and moral obligation to address this crisis. Please do not let Demi and Malachi's deaths be in your vein. Use your power to ensure that
Please
no other
conclude.
family in Bakersfield or in California has to stand where I'm standing today. Thank you all.
Thank you for your public comment. Next up here we have Naomi. Naomi should be receiving that prompt. We're going to move on here to Xavier De Leon. Xavier, you should be receiving that prompt. Naomi will circle back to you.
Hello, my name is Xavier De Leon from Bakersfield and a volunteer with Consumer Watchdog. I was a young father who tragically lost my firstborn son to maternal and infant negligence. My son Malachi faced a post-mortem C-section and still lived for 18 hours. When we filed a complaint on behalf of my son, this board closed his complaint. We never got the final interview before the complaint was closed. So in agreement with the other speakers, please obtain maternal mortality data so we can see patterns and improve the practices of our providers and save lives. Thank you.
Thank you for your vote. Feedback there. Naomi, it looks like your line's open now. You can go ahead when you're ready.
Okay. Hi, my name is Naomi. I'm originally from Bakersfield and a volunteer with Consumer Watchdogs. I was at the Bakersfield Medical Board meeting representing my sister Sabrina Della Rosa, who died tragically due to medical negligence in January 2020. During the Bakersfield Medical Board meeting, we asked for maternal mortality reports with statistics. We've waited 2.5 years for this report, and we are incredibly discouraged at what little information was provided. We appreciate you hosting the meeting in Bakersfield so that you can hear directly from our families that were left broken due to tragic loss of losing so many mothers and babies besides the loss of my sister. We expected to see a report that shared some details, some insights as to why these deaths and long-term harm continue in our community. We did not get that. We seek to uncover the issues behind repeat offender doctors that are tied to disciplinary actions or closed complaints. My sister's doctor is a repeat offender doctor. He is a different repeat offender doctor that is a 32-year-old repeat offender that some of my fellow advocates are talking about. He was on probation when my sister died, and he is currently on probation again and is misleading his patients. We want some answers so we can continue to help our other families. We are asking that you engage in a project similar to the 2015 opiates project, but this time for maternal mortality. It is more dangerous for mothers to have babies today than it was for our mothers. We want to know what patterns exist and how we can help curb this crisis, and you should want those answers too. Thank you.
Thank you for your public comment. This time, President Lawson, I don't see any additional requests in queue.
Thanks, Sean. We'll bring it back to the room. Are there any further comments in the room? All right, we'll bring it back to the board. Dr. Yep.
First of all, I want to thank the staff, but also the public comments. I really think it's about time that we have this topic and deal with that. I personally do not like to see the mortality data. I like to see before that. Medical profession is a safe, sensitive profession like the airline pilot. I like to see the near miss data before it's plane crash. So I think moving forward with a conversation with Department of Public Health, how do we mandate hospital physicians to collect data that complicate post-op, postpartum, or the maternal death, or near death, or neonatal injury and death? I think those more important, how to prevent. Sometimes the physician decision, delay in care, wrong judgment, but sometimes nursing who did not report, and some the hospital. I have seen hospital have no mass blood transfusion protocol. I have seen hospital who would not have hematology that would show up to help the patient go to the IC. So I think it's a big problem. I think we should start a conversation, look for data before the plane crash rather than mortality. But I thank the public for bringing this topic to the board. Thank you.
Thanks, Dr. Yep. Any other comments from members? I just wanted to make a comment, and I wanted to acknowledge that the data, acknowledge and agree with the fact that the data that we have is disappointing. I also wanted to just talk for a minute. The reason that it's disappointing is because the scope of our enforcement program and the scope of our programs generally here at the medical board are quite limited. So we have a limited window as an organization into the scope of maternal and infant mortality and the problem. I've heard a couple of times, or not a couple of times, more than a couple of times, from commenters about the desire for a partnership with the California Department of Public Health. I think that is something we absolutely should do, but I'd like to really broaden that because I think that's also a limited set of data. The data all lives under HHS, so Health and Human Services Agency. The Department of Public Health is a department under that agency in California. And HCI is really the group, I think, in our state government that has been tasked by the state government with consolidating all of that data. So what I think I'd recommend is that our staff collaborate across agencies, because we live in a completely different agency in the state government than those agencies, collaborate to think about, who the best collector of this data is, where are we already working on these problems, and then how can we best try to solve them? Because again, the Medical Board of California has this very limited data set. It's a data set of complaints filed. It's not comprehensive. It doesn't get Dr. Yip to all the various things that you're talking about. And this is such an important issue. The mayor of San Francisco this week announced, I think, what they're calling the Strong Starts program in San Francisco, where they are taking a look at this data. So county departments of public health are very involved in this. So I think it would be worth reaching out across agencies to find out how we can do the best work and look at this data and then make a difference in a really meaningful and positive way. But again, I acknowledge this data is disappointing. It's because of this very narrow window and how we collect complaint data, all of that, this very, very narrow window that the Medical Board of California has. Dr. Mahmood.
I concur with you 100%. Yes. I think the public testimony and the stories are very compelling. Interest is huge and the issue is enormous. There might not be much medical board's control, but I think medical board can do one thing is either have a subcommittee or medical board should come and discuss this. And I think address to all the entities who are involved, at least every single county and all those cities and whatever, to come up with some master plan to address this issue and make a solid plan and make at least medical board can send them guidelines, what they need to do and how we need to come out of this challenge. But I really do hear people's comments on this very seriously. Thank you.
Thanks, Dr. Mahmood. Mr. Watkins.
Yeah, listening to the public again, I feel like what the public, and I don't propose to speak on the public, but there's a theme, a thread that runs through every testimony. And it is this. Everybody on this calls said that on somehow we did not protect them. We allowed the dangerous doctors to come back into the community and reoffend and do all of it. And honestly, if you really want to look at yourself, you say by imposing lenient discipline, deviating from the guidelines, that is what caused and snowballs this situation on almost every account here. And I mean, those folks can write to me and tell me I'm wrong, but that's what I heard. And I think that we should really, based on the numbers I put out, that points more to the fundamental issues that we are facing. That we really, really need to look at how we do what we do to protect the public. Everybody said that we're not protecting them. That's the tragedy of listening to those calls for me personally. Thank you.
Other comments or questions? Mr. Portillo.
So real quick, I like the suggestion, for the staff to work with the relevant agencies to kind of figure out what would be the best way to do that. What, from the executive officer, how long do you think would be a reasonable time for you and the team to be able to do that and come back, report to the board?
I'll definitely reach out to those agencies. And we did work with them to bring that 2023 May board meeting to Bakersfield. So we do have some contacts. So we just need to go back to them and reviewing their website. Some of the data publicly published are still about the same that they presented in 2023. And I may be wrong, but I think there's like a 3-year cycle when they refresh and renew that data. So it was 2023. Now it would be just at the beginning of 2026. So without knowing when they're going to publish the data, are they going to be coming to the board to present something before they publicly and publish those data? I'm not sure. So definitely we can report at the next meeting to see what our effort, outcomes of our effort reaching over to the other side.
Okay, definitely. I think that'd be great. And if
Sure.
also, I may recommend there may be 1 or 2 board members who would like to be help part of those discussions. I would say, that way make sure that you're getting the information that the board would want. So I would say to the extent any of us would be interested, maybe 1 or 2 people. I don't want to overwhelm this, but to make sure that we're getting the right data.
Thank you.
Thanks. And I'd like to encourage more of a task force or an initiative that looks at how we can work together across agencies versus just data sharing, because we can pull down data from different websites, but there are many efforts underway, and we should be at the table as part of those efforts versus just getting presentations or sending that back and forth. So I think that's where I would look for opportunities. If there are no further comments, we're going to take a very, very short 10-minute break. We need to be back here at 4:15 to keep going because we have a few more items on our agenda for this evening. Thanks. Okay, the Medical Board of California is back in session at 4:16 PM. We are going to do a little bit of reordering of our agenda. Agenda item 8, discussion on the December 17th, 2025 Joint Forum on Controlled Substances and Medications for Opioid Use Disorder Access will now be taken tomorrow morning. We are going to move on to agenda item 9, which is discussion and possible action on legislation. And because we've got someone, I think, who's flown in to speak on one of the bills, we're going to do a little bit of reordering of the items. And we are going to begin with agenda item 9F, which is AB 1637, physicians and surgeons medical records. I also just wanted to let members of the public know we are going to plan to end tonight around 5:30-ish, right thereabouts. And so we will get through the legislation we can get through, and the remainder will be on tomorrow's board meeting agenda. All right, AB 1637. Yes, we're going to start with the staff report first here, sir.
Thank you, Madam President. AB 1637 would add language to the Medical Practice Act stating that a physician's medical documentation of their patient is the responsibility of that physician, and that the physician's patient notes, after visit summaries, and diagnosis and treatment plans shall not be changed by anyone other than the authoring physician. Last night, I received a fact sheet from the author's office stating that the sponsor of the bill, the Union of American Physicians and Dentists, took a poll of their members, which found that many physicians reported having their notes changed by their hospital and clinic supervisors, including those who were not a licensed physician. Their fact sheet points out that accurate medical documentation is foundational to safe and effective patient care, that physicians rely on medical records to communicate diagnosis and treatment, and that patients depend on these records for their continuity of care. Further, they note the rapid expansion of EMR systems has transformed how documentation is created, stored, and accessed. Pleased to be joined by a representative of the sponsor who will speak in a moment. Board staff believe that maintaining the integrity of medical records furthers both patient care and the board's disciplinary processes. And on this basis, board staff recommend that you adopt a support position. Happy to answer any questions.
Thank you. Are there any questions or comments for Mr. Bone from the members? We've got one, Dr. Ayala Rodriguez.
Just a quick clarification. So for example, let's say a primary care provider is seeing someone for elevated blood pressure. They instruct the medical assistant to put on the AVS information about low salt diet and things like that. Under this new bill, would that be allowed? Or is that something that the physician per se has to be entering?
I don't know that it speaks to that level of detail, Doctor. Perhaps the public commenters can help to address that question in terms of what their intent is. The language of the bill is very broad, and what I indicated in my verbal comments is essentially the language of the bill.
Additional comments or questions from board members? All right, seeing none, we will, actually, I guess we need to proceed here before we go to public comment with a motion and a second potentially.
If the board wishes, or you can wait.
We'll wait. Public comments from those in the room. Let's make sure your microphone's on if it's not.
Thank you. Thank you, Madam Chair, members. My name is George Osborne. I represent the Union of American Physicians and Dentists. We're the sponsors of this legislation that Assemblymember Caloza has introduced. It's really quite simple. This is probably the least complex piece of legislation I've worked on in my 30-year career. It says that a doctor writes his notes, and only he or she can alter those notes. The diagnosis, the treatment plan, his office notes, his scribe who follows him around the office, as my physicians do. They each have a scribe, and he's talking, and the scribe is typing. Those are his notes, and only he can change them. And we would ask for your aye vote. And I'm happy to answer any additional questions if there are any.
Thank you.
Thank you.
Yes, so just clarifying, I think that it's like assuming like this scribe or this like supportive staff is alphas under the direction of the doctor, and obviously the doctor reviewing, approving to author that information, right? My comments more the AVS part, because I think that the scribes and I think that the medical assistants play a huge role into uploading information and providing information based on the licensee's recommendations.
Yes, I would read it that way. Yes.
All right. Thank you. Okay, Dr. Yap. Yeah. Remember, this is public comment. Yeah, that's okay.
Thank you. Just for the public and also for public member, in technicality, even the scribe, electronic medical record, the doctor is the one electronic signature.
That's
And
correct.
So even your scribe, whoever, cannot change it once I sign it.
That's correct.
So I think that's just simple, but I'm not sure exactly how it changed the practice now because nobody can change my note unless I myself.
In your practice, that may be very accurate.
Even in the
but there are-
hospital setting. we
Sorry, sorry, I got to cut off the back and forth because this is public comment, so we can ask a question maybe later. But I need to go to public comments online also and make sure we do things consistently here. Sean.
Yes, if you'd like to make a public comment on AB 1637, please do so by raising your hand. First up here, we have Rob Gordon. Rob, I'm going to send you that request.
Sean, I assume you can hear me?
We can, Rob. Please
Yeah,
go
I
ahead.
could probably talk for 3 days without sleeping here at least. But I think, first of all, I think most people assume that a law like this already exists. It does look simple. You know, I give you credit for that legislation. I've told my story thousands of times here. It has destroyed my life. I'm now considered a criminal. But a guy named Joseph Sepulveda, a real lying sleazebag, after I reported one of his colleagues for billing fraud, or said I was, and actually said I might report you to the Medical Board of California, he retaliated by fabricating at least a half dozen dangerous sounding psychiatric conditions, wrote a long essay about me, about how horrible I was, and then had one of his subordinates, Derica Aragon Maligros, another liar. It's a culture of liars. This was at a federally qualified health insurance center in San Diego. Long essays. I think people assume that already exists. That might even be legal, that you can just lie about people and just like retaliate. I mean, there might actually be no law against that. It is unbelievable. One more thing, the culture of the family healthcare centers of San Diego, everybody and his dog has access to your medical records. And that is part of their culture. And the reason they retaliated so brutally against me, and the reason why we all are going to be paying for it, is because I asserted the right to control my own records, which I thought was my right. I thought that wasn't even questioned. Exactly the opposite. Anybody who challenges anything in the mental health, that itself is a reason for a new psychiatric diagnosis. Even and then it becomes a party. Then they add diagnosis on top of diagnosis. I think it's gotten to the second level now, where they'll have a fake diagnosis and they'll base a new diagnosis. Your chief executive officer, executive director, whatever the name is, Mr. Varghese, he got in on the party. He documented me with a document header. Personality disorder does not exist in the DSM-5. That is a header. When I trolled him about it, he doubled down and gave me he says I have a general personality disorder. None of these things exist. Those are headers. Under those headers are the actual disorders. And those are supposed to take months to diagnose. But they can and will retaliate against anybody who complains about anything, fraud, abuse, anything in mental health. I have come to the point where I believe nobody, no matter how horrible your life gets, should ask for mental health help. And you also have to know your records are not private. And I always say this, that is even considering me as an exception. I've had the
Please
Attorney General of California seize my medical records and my mental health, my psychiatric file.
Sean.
So everything you know is bullshit. That's all I have to say. Thank you for listening.
This time I don't see any additional requests in queue.
Thanks, John. All right, well, I'm not seeing any further commenters in the room, so we'll bring it back to the board. Are there any comments or questions from board members?
So just to clarify, if it was, so it is the responsibility of the doctor to keep his or her records. If it isn't, it would be considered unprofessional conduct according to law.
There's
Does
an
that
existing requirement to have adequate, appropriate records. Yeah.
Right. So then if my MA changes a record without my knowing, I'm subject to unprofessional conduct. Right. That's what would happen. So it relieves.
Potentially.
Oh, it isn't. Okay. Because I'm just reading the language and I'm thinking, does that open up physicians who violate this aspiration? I mean, this is going to be the law, and now imposes penalty now for not making sure your records are.
So then to the extent that, and I heard this is, I think, from all three doctors that spoke, perhaps then some amendment might be appropriate from the board's perspective to clarify that scribes or others working under the direction of the physician would be encapsulated within this authority, and that wouldn't be a violation if the doctor said, hey, so-and-so, please go make this change. That would be acceptable. Well, maybe that sounds like the start of a supportive amended.
Yeah, so I'll move support if amended.
Seconded.
Thanks. And Mr. Bone, do you think you've captured the nature of that amendment?
Yeah, and we can review this and collaborate with the author and the sponsor.
That sounds like a terrific suggestion.
Can I make a suggestion?
Dr. Mahmood?
Just what you're talking about, just getting those people there. Is there a suggestion can be that whoever person is working, doctor's office or bigger practice or whatever, a notice should be sent to everybody. Nobody can change those notes except the doctor. So doctor is exempted. So people who are going to try to amend, they will be liable. If every practice should be amended, then that notice is given to anybody who has access to record. Nobody can change that because it might be hard for doctors to keep an eye on everything.
I'm not sure how to respond to that, doctor. But I mean, if that would be a pretty big expansion, if I understood you correctly, of what the law is. Could you repeat what you said, doctor?
What I'm saying is, suppose there's a small practice.
Yeah.
And there are like 10, 20 people, and there are 5 people who have access to the records. Somebody is a scribe and a medical assistant, a nurse, or somebody who all have the access.
Yeah.
So if we require them that, okay, once the record is done, it's doctor or doctors who are there. Other than that, nobody can change it.
Right.
So anybody who tries to change that, then that person should be held responsible if we have told them in advance, instead of just bringing back to the doctor, because you can't really keep an eye on every record. It's not possible. If somebody else wants to access that, you cannot block them.
I think that's why I wanted to, because if as stated, it can only be amended by the physician.
Yes.
And if we can amend language to or authorize or delegated individual, then it relieves that scribe, MA or whatnot, as long as you co-sign, because we do that every day.
Or just make it mandatory in the office. Okay, nobody else can do it. So that if they do it, then they were responsible. Doctor won't be.
So in the example you provide, Dr. Mahmood, that might be an employment issue, because if there's somebody who is working for you and then they're altering things, well, then you may have a wayward employee that you need to discipline.
Yes.
And I'm not sure if the statute necessarily needs to address an employee conduct issue, but to the extent that there's things that are happening in larger health systems in the UC or elsewhere, I don't have a response in terms of how to address that, except perhaps then this statute could be a shield, so to speak, for the physician to say, nobody else can change these notes because these are my notes, and therefore, I don't know. I'm trying my best to try to respond to your good comment, Doctor.
I mean, isn't the issue, this lives in the Medical Practice Act, and the Medical Practice Act has a certain jurisdiction, and we don't necessarily have jurisdiction over all of those other
Correct.
people. And in order to be able to discipline those other people, we would need to significantly expand our jurisdiction.
Or we make referrals, if there's a
Exactly.
nurse or somebody else, we'll make appropriate referral.
All right, we have a motion and a second pending. So if there's no further discussion, we will take a roll call vote on that. Ms. Streller.
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez,
Yes.
Ms. Chung,
Yes.
Ms. Holmes. Yes. Dr. Mahmood,
I'll abstain.
Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins, Dr. Yip,
Aye.
Ms. Lawson.
Yes. All right, that motion carries. Thank you. Thanks for joining us.
Thank you, Madam Chair.
We
Member.
are going to move on to agenda item 9A, AB 408 Berman Physician Health and Wellness Program.
So I did miss some of my introductory comments. I'll skip some of them for time, but we do have a blue and green color-coded tracker chart for our new members that indicates which bills are intended to be discussed and which ones are not. Blue ones have not been amended since our last meeting and do not require a discussion today. The exception to that, however, is AB 408, our sponsored legislation to create a statutory framework for a physician health and wellness program. Our practice has been to take public comment on that. So I do not have any updates on the bill. The legislature just returned from their recess, and there's not been any amendments or activity on that bill in that time. So unless there's any questions or for me, Madam President, or the members, I would suggest we go to public comment on AB 408.
Are there any questions or comments from board members before we take public comment? Mr. Portillo?
Just have one question. I know that when it went through appropriation, it was said no fiscal impact because the bill is only authorizing the board to do such a program. It's not mandating it does so.
Correct.
But I suspect that their expectation is that we will create one. Would it be appropriate to kind of have our budget people start looking at what could such a program have impact on the board? From a financial point of view, because I know if we're looking at reserves of 3 months, we want to grow it to 6 months. That maybe doesn't hurt to start looking at what the fiscal implications would be should we proceed with such a program.
Some of that work and discussions have begun at an early level, Mr. Portillo. Some of the details matter in terms of a contract, and so as the bill sets up a statutory framework, it states that there's going to be an RFP with an administering entity in order to run the program. And as the board's, if AB 408 is approved, and then the board would be able to really dig into the to the contracting process and, see about working with external parties in that regard.
Do we expect there's going to be a cost borne by the board as part of that contract?
It potentially, it would depend upon how the contract is constructed. We may need to seek new budgetary authority to authorize spending associated with the contract.
So it wouldn't be passed on to, you wouldn't charge people for this. We would be covering all the costs.
What we understand is normative across the country is that there can be a variety of funding sources to help pay for the administration as well as the care that is provided. And that typically that does include some portion of participant payment.
Cost sharing. Okay,
Yeah.
great. Thank you.
Other questions, comments? All right, we'll open it up for public comment. There are public commenters in the room on AB 408?
Hello, my name is Lucas Evanson, and I'm speaking on behalf of the California Medical Association. CMA appreciates the board and board staff for their continued leadership in advancing a physician health and wellness program. We recognize the significant time and care that has gone into developing this long overdue solution. There's still work to be done to ensure that California is no longer lagging other states in effectively addressing physician impairment. CMA looks forward to continuing to work with the board this year as AB 408 continues through the legislative process. Thank you.
Thank you for your public comment.
Good afternoon. I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Multiple members of the Senate Business and Professions Committee, including the chair who voted no, had serious concerns with the bill. Senator Menjivar expressed her concern regarding doctors who are practicing while impaired. Doctors who have already harmed someone are not the only ones who pose a risk to patients. Proponents have said that the bill does not change any requirements if a patient has been harmed, but AB 408 does change the rules if a doctor was caught using drugs or alcohol just short of harming someone. The bill would allow doctors to seek treatment to avoid discipline, even if they were impaired on the job. We urge you again to amend your bill to make a clear distinction between doctors who are truly volunteer participants and those who are only in treatment, to avoid discipline after a complaint is filed with the board about their substance use. The patient protections and uniform standards, including disclosure to the board and consequences when a doctor fails a drug test, must be applied to any doctor the board refers to the program. A doctor who seeks treatment of their own accord can maintain confidentiality. The goal of connecting doctors with treatment before their substance use poses a risk to patients is a laudable one, but doctors still hold our lives in their hands. The board has a responsibility to protect patient safety by acting when a doctor's problem has become acute enough to be reported to the board, whether through a patient complaint, hospital disciplinary report, arrest record, or other method. The legislature enacted standards for oversight and accountability to ensure any future diversion program did not expose our families to harm, as the last program did. This board is willing to throw those uniform standards away only to claim to use them for physicians with a probation order that includes uniform standards. How will any future physicians obtain probation orders when the board can choose to refer doctors to the program in lieu of discipline? You're throwing away the uniform standards for, as you state, best practices, whatever these best practices may be. Believe me, you already have the best practices in your toolbox right now. These best practices are uniform standards for substance abuse and licensees. You have stated that experts informed you that allowing participants to bypass uniform standards would effectively encourage doctors to seek help early. This claim is not supported by facts. The former diversion program had no uniform standards and had the same confidentiality that AB would replicate, and the participation rate was still low. It attracted only about 250 substance abusing doctors at any given time. You've stated that the prior program failed because it was underfunded and poorly managed, yet you have no budget for this program and no funding plan whatsoever. You're working hard to go back to the days when you left the public in the dark. This does not work for the public, nor for the doctors and other healthcare professionals who are stuck working with these doctors. Thank you.
There are other public commenters in the room? All right, seeing none, Sean, let's open it up online.
Yes, I see 7 individuals, 8 now, with their hands raised for AB 408. If you'd like to make a public comment, please raise your hand. First up here, we have Kimberly Turbin. Kimberly should be receiving that prompt.
Hello, my name is Kimberly Turbin, and I am from Reseda, and I volunteer with Consumer Watchdog. I have watched this issue closely. It concerns me because I am responsible for making the best healthcare decisions for myself and my children. But how can I do this without having the information I need to make a responsible decision? For the past 10 years, you have had the ability to recreate a diversion program that had to adhere to the uniform standards, but you chose not to recreate the program. Why? We hear your complaints that you have gone. We hear your complaints that have gone without a program for so long, but why have you gone without a program when legislation was passed 10 years ago, calling on you to recreate the program? Did it have anything to do with you not wanting to adhere to the uniform standards as the law required you to do so? Was it because you did not want physicians to face consequences for their actions? What about the patients? Where are our rights in all of this? The only reason why we know of substance abusing doctors is because you don't have a program and you are left to investigate the cases and offer probation. This action on the public document gives the public some information. Your mission is to license physicians and protect the public. You need to bring some balance to this bill to ensure that the public is protected. Because right now, this bill, it does not protect us. It only protects the substance abusing doctor. Thank you.
Thank you for your public comment. Next request here is Rob Gordon. Rob, you should be receiving that prompt.
Yeah, hi. Again, I hardly know where to start, but let me tell you what I consider this to be. I consider this to be trolling. Now, everybody has been on the internet. You know what trolling is. It's when its purpose is to make you angry and disgusted. And that's exactly what I believe you're doing, Medical Board of California. And it's what you did for 2+ years. I had to listen to this after having my successful mental health treatment program criminalized by a lying con man I've never met, and then had the good psychiatrists, the genius, you're brilliant people, you're brilliant genius, then charge the good guy, with whatever, malpractice for treating me or whatever. The 100,000 plus in taxpayer money, and it's still counting. A lot more than that. I haven't added up yet. It's a fortune. But I'm going to do a little bit different this time because I have to. We can't keep doing this. We have to attack people politically, non-violently, but we have to attack anybody who supports that. And this could be the most important politicians in the state. I have attacked the governor. I haven't revealed that yet. And it was successful. He ran away. And I did it nicely. It was really nice. I'll tell that story later. It was part of when I was a member of, it was on the California War on Independence in 2020. I got knocked out of the playing field by your con man who you support, who was setting up forced urine programs, forced urine testing programs in our community, San Diego. He was a fake psychiatrist. He later became a fake professor at UC Medical. And that's not an issue either.
Can we
Anyway,
have
I'll
you
let you go.
stay
You don't
on
want to hear it,
topic,
I know.
please?
So good luck.
Very
Bye.
interested in your thoughts on AB 408.
Are you saying, do I have thoughts on it? I told you, I'm
I'm
going to
just
attack
asking you
anybody
if you
who
would please
supports.
stay on topic.
Are you saying you didn't understand me? I don't understand your question. Could you repeat your
Please
question?
speak to AB 408.
I said I'm going to retaliate against anybody who supports it. I'm against it. Does that help?
Yes, that's clear.
Okay.
Does that
Thank
conclude
you.
your comment?
And I'll be retaliating politically, non-violently. I'm done. Go ahead.
Thank you for your public comment. Next here we have Daniel Blaney Cohen. Should be receiving that prompt. Daniel, your line's open. Just make a public comment.
Good afternoon, and thank you, Madam Chair. My name is Daniel Blaney Cohen. On behalf of the American Medical Association, thank you to the physician and public members of the Medical Board for holding today's hearing. I'm a senior attorney with the AMA and representing the AMA's strong support for Assembly Bill 408. The AMA supports Assembly Bill 408 because it has the key provisions necessary to support a physician health program, thrive as an evidence-based comprehensive system to help physicians with potentially impairing health conditions obtain care and protect consumers from physicians who are not ready to safely return to practice. Nationally, PHPs have a successful track record of working with impaired physicians and their treatment providers to focus on whether and how to safely return the physician to caring for his or her patients. Successful PHPs ensure that impaired physicians do not return to patient care unless they can safely do so. Successful PHPs have strong relationships with state medical boards to ensure that if a PHP enrollee does not complete his or her treatment, the medical board retains full authority to prevent that licensee from returning to practice. AB 408 would further these successful principles in California. Across the country, PHPs assist thousands of physicians per year through a confidential, therapeutically oriented model that supports illness remission, ongoing health support, and trusted verification of safe practice. AB 408 would create the structure necessary for California to ensure that physicians who return to practice are able to provide safe, competent professional care and ensure that physicians who cannot return to practice do not. The AMA commends Assemblymember Berman for his efforts, and we encourage the Medical Board of California to support AB 408. Thank you very much.
Thank you for your public comment. Next here we have Cheryl Marcel. Should be receiving that prompt.
Good afternoon, Cheryl Marcel. Can you hear me?
We can. Please go ahead.
Great. Thank you. Cheryl Marcel. I'm the Executive Director of the California Society of Addiction Medicine. On behalf of our member physicians, thank you so much for your strong support of AB 408. We stand with the medical board in strong support of AB 408. We emphasize that addiction is a treatable chronic medical disease and that prevention and treatment outcomes are comparable to other chronic illnesses. We note that the CDC acknowledges addiction as a chronic but treatable disorder, and it is essential for effective, compassionate communication and care. In closing, addiction is a chronic, treatable medical condition, not a moral failing. With evidence-based care, people can and do recover, and we urge your aye vote in support of AB 408. Thank you.
Thank you for your public comment. Next here we have Dylan Elliott. Dylan, you should be receiving that prompt.
Thank you very much. Can you hear me okay?
We can. Please go ahead.
Thank you. Dylan Elliott here today on behalf of the California State Association of Psychiatrists. I would just start by saying we align ourselves with the comments made by our colleagues with the California Medical Association. Simply supporting physician wellness inherently supports patient care. I just would also like to address, with reference made to some previous public comment, that we hope the board takes things like that seriously with threat of retaliation against individuals who support this kind of initiative. Want to underscore that kind of comment is inherently the stigma that this bill is trying to address. Appreciate the board's consideration and thank you for the opportunity to comment.
For your public comment. Next here we have Lizzie Guansana.
Good afternoon, Lizzie Guansona here on behalf of the California Academy of Child and Adolescent Psychiatry to voice our support of AB 408. And similarly to my colleague before me, I just want to echo the comments of our colleagues at the California Medical Association, and also want to emphasize that investing in physician wellness is an investment in the health of all Californians. Thanks for the time today. I appreciate it.
Thank you for your bill. Next here we have Monique Himes. Monique, you should be receiving that prompt.
Hello, I am Monique Himes. I'm from Bakersfield and a volunteer with Consumer Watchdog. The issue surrounding the substance abusing doctors and your new direction with a confidential diversion program is very important to the public. If you are concerned with early intervention, then why is the board and the hospitals not requiring substance abusing providers to enter private rehabilitation programs? In the many private programs, the substance abusing doctors would not have to worry about consequences. Most importantly, they would be seeking help on their own, but that is not happening. We all know that substance abusing doctors were not voluntarily entering the former diversion program on their own. The numbers of pure self-referrals or voluntary referrals were very few, with full confidentiality and with no uniform standards, which means no consequences. This issue affects all of us. There is a doctor in Bakersfield who works in association with the OBs. Because we do not have a diversion program, this board was forced to take action and issue an interim order for random drug testing. There was little to no information on the order, but the provider accepted it instead of a license suspension. We later learned that the Bakersfield substance abusing doctor used cocaine daily in 2024. This same doctor is the chair of a program at one of our local hospitals. Had we had a diversion program, this would not have happened. The board would have referred him to the diversion program and we would never know. We have to have balance here. Your full commitment cannot be in just protecting the profession. You're required to take actions to protect all of us, including the patients and our families. Thank you.
Thank you for your public comment. Next, here's Denise Johnson. You should be receiving that prompt.
Good afternoon, Madam Chair, members of the board. Once again, my name is Denise Johnson. I'm from Tracy and a volunteer with Consumer Watchdog. The issue of substance abusing doctors is important to the public. We were on a path to approve regulations to follow legislation passed 10 years ago to recreate a diversion program that adhered to uniform standards. Then you changed course and decided to seek this legislation that basically does away with the previous legislation that required you to recreate this program and also allows you to not follow SB 1441, the legislation that called for the creation of these vital standards. Now, 10 years later, you're saying that we have gone without a program for this long, but we have gone without a program because of your inaction. You did not want the doctors to face consequences that the law requires them to. You claim that this legislation moves forward with best practices, but you have not identified them. Best practices for Californians that do not follow the law and drive while intoxicated, they face discipline. It saves the life of the driver and the lives of drivers. How is it any different in a hospital setting? It should not be any different in a hospital setting. You should want your providers to be safe in a hospital setting, and you should want us, the public, to receive safe care. How can the board advise an unidentified participant who has violated a portion of the program, whether it was skipping a random drug test or failing a drug test? How can this board encourage continued participation in the program in lieu of discipline if they don't know who the participant is and what their background of substance abuse and patient harm details? Yes, we see that you can request the participant's identity and summary of findings, but at what point will you take that action? We feel that you are taking us backwards to a time when we had no information and were left in the dark. It is your job to protect us as much as to license our providers and monitor their licenses. Let's focus on and strive for quality medicine for our patients and doctors. Thank you.
Thank you for your public comment. Next, here we have Maria Ibarra Navarrete. You should be receiving that prompt.
My name is Maria Ibarra Navarrete. I am from San Jose, a volunteer with Consumers Watchdog. As a sister who lost her brother to medical negligence, I feel strongly about this bill and our opposition to this bill. Before my brother's tragic death, I have been a registered dental assistant for the past 20 years. At any time, I could be subject to random testing within the past clinics I worked at and served. And if I did anything to put my license at risk, there would be consequences. Therefore, holding the capacity of the license I hold and to what scope of practice I have within my license is imperative for physicians to be held to such standards when providing care to their communities they're serving. AB 408 does not reduce patient safety risk and does not enhance patient safety. This board keeps referring to aligning with best practices, but you're not stating what those best practices are. Now, if you are claiming that you are adhering to what the FSMB is documenting, well, they may claim they're concerned with consumer protection, just as you claim in words only, but not in your actions. How do you believe that this program will prioritize early intervention? The past abolished diversion program had incredibly low true voluntary participation. And you all know that. Exactly when does a physician conduct become his or her responsibility? You know, and we know that confidentiality and no uniform standards did not draw people into the prior diversion program. You also know that it will not draw doctors into this program either. You know, and we know that disciplinary actions, specifically probation, has worked. It has given the public notice of this issue, but you don't want the public to know that their doctor is a substance abuser, do you? That is really the issue here. The participants who truly volunteer to participate in this program will absolutely be able to hide their drug or alcohol addiction. We, the patients, have the right to know who is in the program. You, the board, can decide to refer the substance abusing doctor to the program instead of discipline. And now discipline is the only way for any of us to know who is addicted to drugs and who is not. The only way that substance abusing doctors could not hide their issues was to have to face a review and discipline the medical board from the medical board. But let's not kid ourselves. The board that it is in place to protect consumers and licensed physicians wants to eliminate our consumer protection. We now have and put all of us back at risk. Thank you.
Thank you for your public comment. Next here we have Malini Mandanahali.
Hello, can you hear me?
We can. Please go ahead.
President Lawson and members of the board, good afternoon. My name is Malini Madanahali. I am a physician in a large group practice in Palo Alto in the Bay Area, where I chair the Health and Wellbeing Committee of the group. Today, I'm speaking on behalf of California Public Protection and Physician Health, or C3PH, in support of AB 408. Thank you for the opportunity to comment. We express our thanks for the careful work of the board members and staff that has led to sponsoring this bill. C3PH appreciates the board's clear focus on patient protection and on building a program that can identify risk early and respond effectively. Most importantly, C3PH supports AB 408 as a physician health and wellness program that adheres to national best practices with defined pathways for reporting to the board when patient safety requires it. C3PH continues to communicate with the board and staff on efforts that will bring the program to California and achieve the goals of strong patient protection. Thank you very much.
Thank you for your public comment. Next here we have Tracy. You should be receiving that prompt.
I am Tracy Dominguez and I am from Bakersfield. I'm a volunteer with Consumer Watchdog. This issue is important to the public. We have enough issues in healthcare to manage without having the right to know that our doctors are substance abuse doctors. As mentioned earlier, there is a substance abuse doctor in Bakersfield who is the chair of a program at one of our local hospitals. Because we do not have a diversion program, the board was forced to take an intern order for random drug testing. The doctor chose the drug testing instead of the license suspension. We later learned that the doctor was using cocaine daily in 2024. We are happy that the board took action, but I fear what would have occurred if the diversion program you want would have been in place. My guess is that the board would have diverted him to this program and we would have never known. This is why we need a program with the consequences that the legislation requires you to follow 10 years ago. We also state that the former diversion program failed because it was this one's unfunded. Yet you have no funding for this program and no funding plan intended. Please remember your mission is to protect patients, not doctors. Thank you.
Thank you for your public comment. Next here we have Edwin Kim. Edwin, you should be receiving that prompt.
Hi, my name is Dr. Edwin Kim. I serve as the president-elect of the Federation of State Physician Health Programs and a practicing addiction psychiatrist in Palo Alto. The FSPHP provides education guidelines and structured reviews to support physician health programs across North America. I'm here to inform the medical board that the FSPHP strongly supports the passage of AB 408. California currently stands as an outlier in physician health, being one of only 3 states without a fully operational PHP. AB 408 represents a critical opportunity to align California with the proven models utilized in nearly every other state, prioritizing early intervention to protect both the physician workforce and, equally important, patient safety. AB 408 creates a resource for the state by implementing a system functioning in other states to encourage physicians to seek help before illness progresses to an impairment, and in turn before impairment impacts patient care. The internationally accepted PHP model facilitates early self-reporting and support, effectively navigating illness and unsafe practice while maintaining rigorous safety standards. It is the model that balances the rights of the participants with the supreme duty to protect the public. The efficacy of the model is backed by decades of experience and data. Physician health programs adhere to FSPHP guidelines and achieve recovery rates that far exceed those available to the general population. AB 408 establishes a clear statutory framework to offer California's board to work with physicians and its consumers a long overdue mechanism to improve the healthcare system. With the Physician Health and Wellness Program, California's communities are given a trusted way to help maintain the healthcare workforce. The FSPHP continues to support AB 408 as we have from its inception to help retain physicians in a state facing a shortage, to improve patient safety, and to rebuild an authorized physician health program. Thank you.
Thank you for your public comment. Next here we have a caller from area code 415. You should get a prompt to press *6 to unmute. Area code 415, you got to hit *6 to unmute. There we go.
Hi, can you hear me okay?
We can. Please go ahead.
Well, thank you. Good afternoon. My name is Dr. Shannon Udovic-Constant. I'm a pediatrician who practices in San Francisco, and I'm the immediate past president of the California Medical Association. Nearly 2 years ago, I was able to provide public comment encouraging the board to consult national experts to share best practices on physician health programs as it considered implementing such a program under its existing authority. Since then, the board has done exactly that. It has heard from national experts, withdrew the prior regulations, and introduced legislation aligned with those national best practices and shepherded that legislation through the legislative process. On behalf of CMA, I want to express our sincere gratitude to the board and its staff for the work that has brought us to this point. As you have heard, physician health programs are operating successfully in 47 other states. These programs demonstrate that early confidential intervention protects patients while supporting physicians in recovery and continued safe practice. They are designed to identify impairment before patient harm occurs. In my leadership role at CMA, I've had the privilege of meeting physicians across the state. I have heard from physicians whose practices and sometimes even whose lives were saved because they had access to a confidential physician health program. Physicians enter this profession to help people. Like anyone, physicians can experience health challenges, and when they do, they should have a non-punitive place to turn. California remains one of the few states without a modern physician health program aligned with national standards. That gap leaves both physicians and patients without proactive safeguards that exist elsewhere in this country. California patients and physicians deserve a program that helps physicians get help before medical conditions become a problem in a physician's medical practice. AB 408 would give the board clear authority to establish a physician health program grounded in evidence, built on national best practices, and designed first and foremost to protect patients. It would create a structured pathway for physicians to seek help early before medical conditions jeopardize their ability to practice safely. Thank you very much for your time.
Thank you for your public comment. At this time, there are no. Oh, one just came in here. Eric Andrews, you should be receiving that prompt.
Sorry, can you hear me? I undid my mic.
We can, Eric. Please go ahead.
Okay, great, thanks. A confidential program that allows impaired physicians to keep treating patients without meaningful disclosure, strong practice restrictions, or rapid enforcement action when they relapse or violate terms is fundamentally at odds with the mandate. I'm here as a California consumer and family member who relies on this board to make protection of the public not just a slogan, but a real priority in every decision you make. State law is very clear. When public protection conflicts with any other interest, including physician rehabilitation or privacy, public protection must be paramount. That word has to mean something in how you design and operate any physician health and wellness or similar program for doctors with addictions or impairments. Sorry, I'm out of breath. I ran in here. We have already seen that happen when programs like the old diversion program fail. Patients are harmed when problems are handled quietly in the background. You know this history. Recreate, and for the new board members who don't know the history, look it up. Recreating anything that looks like secret second chances behind closed doors repeats those mistakes. If you move forward with a health and wellness program, at minimum, it must exclude from a confidential track any physician who has already shown themselves to be at risk through complaints, arrests, 805 reports, or prior discipline. Require immediate reporting to enforcement of any relapse, missed or dirty test, rule violation, or termination from the program with timely practice restrictions or removal from practice when safety is at stake. Apply at least the same level of monitoring and standards that would exist on formal probation, not weaker ones cloaked in the language of wellness. Ensure genuine transparency. Patients should not be the last to know that their doctor is struggling with an impairment that could affect their care. I'm asking you today to measure every aspect of this program against one simple test. If a patient were sitting in this room, knowing what you know about impaired physicians and past program failures, would they feel safer or more at risk? If the answer is not clear, safer, then the program structure does not meet your legal or ethical duty to protect the public. Please design and enforce any physician wellness program so that patient safety truly comes first, in fact, and not just in language, and not to satisfy Christina and her CMA buddies. Thank you.
Thank you for your public comment. At this time, there are no additional requests in queue.
Thanks, John. We'll bring it back to the board. Are there any comments or questions? This is not an action item for us. All right, seeing none, we're going to move on
to AB 1587, continuing to skip out of order. We do have some folks that are online have been waiting for this item to come up. So
1587, that is agenda item 9D.
Yes, it is. This bill is attempting to update the authority of a pharmacist so that they may refill a prescription medication for a patient's life-threatening condition if they cannot secure a new prescription before their supply is exhausted, and if the pharmacist or pharmacy has previously furnished that medication to the patient in question. The intent of the author is to help ensure that patients don't go without necessary medications if they do not have a current prescriber. They believe a patient is at particular risk of this happening if they are on a Medi-Cal health plan or are unhoused. There is an existing statute in the pharmacy law within Business and Professions Code section 4064, which allows a pharmacist to refill a prescription if the prescriber is not available. The pharmacist can do that refill if, in their judgment, failure to do so might interrupt the patient's care and have a significant adverse effect on their well-being. That current law is quite broad. However, the author's office believes that law may not be clear enough to accommodate patients who do not have a current prescriber. In light of this, the author's office intends to update their bill to instead amend that code section, BPC 4064, which is shown on pages 2 and 3 of the analysis. Their purpose is to make it clear that someone can get up to a 60-day supply of a medication for a life-threatening condition if the pharmacy or another pharmacy under common control has previously furnished that drug to the patient and the patient is unable to secure a new prescription before their supply of the medication is exhausted. Further, they propose to add a liability shield that could prevent a pharmacist from facing what we believe could be appropriate sanctions if they act in an unprofessional manner in conjunction with this proposed authority. This board has typically opposed this type of language as being contrary to consumer protection. This bill is within the jurisdiction of the California Board of Pharmacy. Therefore, your staff recommend that you do not take a position on the bill at this time. Instead, we suggest that you direct us to write a letter to the author, copying the appropriate legislative committees and the Board of Pharmacy that states our concerns with liability shields and urges the author to collaborate with the Pharmacy Board to determine whether any additional legislation in this area is necessary. We would then be happy to report back on any developments of this topic at the next board meeting. Happy to answer any questions.
Thank you, Mr. Bone. Are there any questions or comments from members? Dr. Mahmood?
Yeah, I think the intent on the bill is very true. There are so many people, especially with present insurance circumstances, a lot of patients are being dropped from the plans, and there are many medications which are basically life-saving, and if they don't take it for a few days, it's going to be a problematic. But I agree with your proposal that for us to exempt anybody from any liability would be a little bit too much out of our thing. And the other thing is 60 days the right thing or the 30 days? Because if somebody's taking life-threatening life-saving medications, they need to be seen and they need to find a doctor, somebody else to see. If the medication needs to be adjusted, they need to stay on the same thing. For example, some medications need a level to be done. And if his kidney function goes a little disarranged or kind of like, I don't want to go to the details of the medications, but I think somebody needs to be seen by the physician. So I think two things should be considered. Number one is we need to debate about 30 or 60 days. And I would be flexible on 60 days, but I think 30 days would be better. But I agree with, we need to direct them to reach the Board of Pharmacy about their stuff.
And to your point, Doctor, the existing law that authorizes a pharmacy already does not state a particular time period or quantity of the medication. So again, that speaks to, is this necessary? And since this is in the bailiwick of the Board of Pharmacy, thus the recommendation for them to collaborate.
That's even better.
Comments? Questions?
I was going to second Dr. Mahmood's motion.
Uh,
I thought he had a motion there to agree with.
That the staff, to move the staff recommendation?
If he doesn't, I'll support it.
Okay.
Yeah, I thought I heard that.
Okay.
Okay, we have a motion and a second. We need to go to public comment. Are there public comments in the room? Are there any online, Sean?
Yes, if you'd like to make a public comment for AB 1587, please do so by raising your hand. First up here, we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, hi. The bill itself sounds fine to me. I'm all for it. Since I lost my health insurance from UC Health San Diego in retaliation for mentioning to a psychiatrist that I'd been criminalized by Family Healthcare Centers of San Diego, I have not had a doctor, and I've had to hustle for medications all over the place. We're talking about Flomax. So thank you guys for that. But what I have to get in as a comment really quickly is that I needed the name of that guy from I think it was the American Psychiatric Association. That went by too quickly, and your chat is closed off even for the hosts. So I'll be writing you an email message about that. But that is how it starts. I said clearly, political retaliation within California law, not U.S. law, which is less restrictive. California law is more restrictive. I will absolutely follow California law. I'm going to need his name because that organization was also on legal papers, even though they weren't involved. So thank you. That's all I have to say.
Thank you for your public comment. Next here is Adam Bowman. Should be receiving that, bro.
Hey, Madam Chair and members of the medical board. My name is Adam. I'm the Ledge Director for Assemblymember Ta and the staff member responsible for this bill. I would like to begin by saying that the Assembly member is amending the bill. Currently, Aaron had stated what the amendments are and in the analysis. Also described in your analysis, AB 1587 would allow pharmacists to furnish a prescription for life-threatening conditions like cancer, diabetes, or schizophrenia, for example. But the main intent of this bill is to ensure continuous access to essential life-saving medication for individuals who have lost their physicians and are searching for a new one. This is essentially relevant for homeless or Medi-Cal patients finding a new physician can be difficult and take a lot of time, especially for people who are impaired. While existing law allows pharmacists to fill prescriptions when a doctor is unavailable, it implies that patients must have a current doctor. This does not help people who have lost their physicians due to retirement or leaving the Medi-Cal system. As you're aware, physicians are leaving Medi-Cal due to inadequate reimbursement. As noted in your analysis, approximately about 130,000 providers participate in the Medi-Cal program, while 14.9 million Californians are enrolled. This creates a patient to physician ratio of 1 to 114. If a patient loses their physician, reviewing the application for a new doctor may take up to 45 days, followed by a 30 days to select a new physician. There is also a wait to actually see the physician in order to have a new prescription written. Meanwhile, if a patient is on a life-saving medication, they can run out of it or be forced to ration their supply. AB 1587 is not intended to give every person the ability to receive any medication they ask for. In fact, it is narrowly tailored to only include established prescriptions of life-saving medication. This proposal was brought to us by pharmacists from our district who have patients they see all the time and have working relationships with, but are worried about refilling a critical, long-standing prescription without a doctor to communicate with. And I also know that there was the analysis raised concerns about liability protections. According to the Pharmacist Code of Ethics, Section 1 and 2, pharmacists should hold the health and safety of patients to be the first consideration. A pharmacist should render to each patient the full measure of his or her ability as an essential health practitioner. And then Section 2, a pharmacist should never knowingly condone the dispensing, promoting, or distribution of drugs or medical devices or assist therein, which are not of good quality, which do not meet standards required by law or which lack therapeutic value for the patient. And punishment for a pharmacist who fail to follow the code of conduct range from private reprimands to license losing their license, depending on the severity of the offense. And I'm here to offer any answer any questions that you have.
Thank you for your public comment. This time, there are no additional requests in the queue.
Was that our last public comment, Sean? Sorry, couldn't hear you. Great. We will bring it back to the board. Are there any further comments or questions from board members? Okay, seeing none, I think Dr. Tolbert.
I was just going to say, as I kind of reflect on this from an emergency medicine position and seeing patients in the ER, I think 60 days is probably a little bit better than 30, because I often find that patients are not able to follow up with a doctor if they don't already have one, and the wait time for primary care visits is pretty long.
Thank you. So it sounds like we have a motion pending to support
this-
staff's recommendation.
Yep.
Any further comments? All right, let's do a roll call vote. Ms. Struther?
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez,
Yes.
Ms. Chung, Ms. Holmes,
Yes.
Dr. Mahmood,
Yes.
Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Aye.
Dr. Yip,
Yes.
Ms. Lawson.
Yes. Right, we are going to make full use of the up to 5:30 time I mentioned. So we're going to take agenda item 9E, AB 1598.
Thank you, Madam President. This is another bill that falls within the jurisdiction of a different licensing board. This one is the Board of Behavioral Sciences, or BBS. The BBS is the sponsor of AB 1598, and it is intended primarily to address matters related to faith-based or pastoral counseling or therapy. The bill also includes some changes that are intended to add consistency to various provisions across the Medical Practice Acts within the jurisdiction of the BBS. The reason why this is on our board agenda is that when the bill came to our attention, we noticed that Current law in some of those practice acts and this bill includes language that may inappropriately attempt to prevent a physician from advertising services that they are authorized to perform under the law. Specifically, I'm referring to the language stating that a physician may not use a title or description of their services that uses the word psychosocial or psychotherapy. Physicians are authorized to use any system or mode of treatment to treat their patients for any physical or mental condition. I connected with the BBS staff last week on this, and we had a very positive first discussion on this regarding our concerns. And I look forward to continuing to collaborate with them and the author's office to resolve this concern. Therefore, at this time, we do not recommend you adopt a position on the bill. Rather, we suggest that you direct the staff to continue to working with BBS and the author to address this concern, report back at the May board meeting, and hopefully inform you of any amendments that have been taken to resolve the matter. Happy to answer any questions.
Thank you, Mr. Bone. Any questions or comments from board members? Questions or comments from the public? How about online, Sean?
Yes, if you'd like to make a public comment here on AB 1598, please do so by raising your hand. Give me a few seconds to queue up. Not seeing any requests at this time.
All right, we'll bring it back to the board. I think I need a motion.
I move to table the bill, like.
Move the staff recommendation?
Yes, okay. move-
Staff recommendation.
I second.
All right, we have a motion and a second. Is there any further discussion? All right, we'll do a roll call vote. Ms. Struther?
Mr. Arkatov.
Yes.
Dr. Ayala Rodriguez.
Yes.
Ms. Chung. Ms. Holmes.
Yes.
Dr. Mahmood.
Yes.
Mr. Portillo.
Yes.
Dr. Solis.
Yes.
Dr. Tolbert.
Yes.
Ms. Torres.
Yes.
Dr. Sy.
Yes.
Mr. Watkins. Dr. Yip.
Yes.
Ms. Lawson.
Yes. All right, that motion passes. And our last item for this evening is going to be agenda item 9G, proposed trailer bill language on menopause coverage.
Thank you, Madam President. This is a budget trailer bill, which was published on the Department of Finance's website, but has not been included into actual legislation yet. Trailer bill language, sometimes referred to as TBL, are codified statutory changes that are intended to support or complement funding on topics that are addressed in the State Budget Act. This proposal is very similar to AB 432, a bill that the board supported last year, and it authorizes a qualifying physician who completes continuing medical education or CME courses in perimenopause, menopause, and postmenopausal care to receive double credit up to a maximum of 8 hours. So if they took 4 hours of courses, that would net them 8 hours of credit towards their 50-hour CME requirement that they must fulfill every 2 years. To qualify, the proposal says that a physician must be board certified as a general internist, family physician, obstetrician and gynecologist, cardiologist, endocrinologist, neurologist, or psychiatrist. Those descriptions of certification, however, are a bit imprecise, as the specialty boards use different terms, which are noted in the right column of the table on page 3 of the analysis. Board staff have been in contact with the Department of Consumer Affairs and have provided suggested updates that would clarify those terms so that they conform to the relevant specialties that are described on the website of the American Board of Medical Specialties, or ABMS. Making those adjustments will help ensure that licensees have clarity on whether they will qualify. Another qualifying condition is that the physician's medical practice must have a patient population composed of 25% or more adult women under the age of 65. There are other changes in the proposal relative to AB 432 in the requirements placed on health insurers to provide coverage for various treatments for these important conditions. Health policies, though, are generally not addressed by the board, so the analysis only contains high-level information on those insurance requirements. Despite the differences between AB 432 and this proposal, both are aiming at the same goal: to provide an incentive for physicians to take courses on topics related to menopause and preserve patient access to that necessary care. Accordingly, staff recommend the board adopt a support position and direct staff to continue to work with stakeholders to clarify the terms in the bill surrounding medical specialties. Happy to answer any questions.
Thanks, Mr. Bone. Any comments, questions? Dr. Sy?
I think this is long overdue. I move to support the adopt it.
Thank you. We have a motion and a second. Any further comments or discussion?
A second.
Okay. I think Dr. Yip seconded.
Oh, sorry.
That's all right.
That was you moved the staff recommendation, Doctor. Thank you.
Great. Any comments, questions? All right, let's open it up for public comment. Any public commenters in the room? How about online, Sean?
Anyone would like to make a public comment on this proposed trailer bill, please do so by raising your hand. Give you a few seconds here to queue up. Not seeing any requests at this time.
All right, we'll bring it back to the board and we will do a roll call vote on the pending motion.
Mr. Arkatov,
Yes.
Dr. Ayala Rodriguez,
Yes.
Ms. Chung,
Yes.
Ms. Holmes, Yes. Dr. Mahmood, Mr. Portillo,
Yes.
Dr. Solis,
Yes.
Dr. Tolbert,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins, Dr. Yip,
Yes.
Ms. Lawson.
Yes, that motion carries. It's
I don't think we can
5:26.
do any more in the next 4 minutes. Madam
I think that we'll conclude this meeting at 5:26 PM and we will see everybody back here at 9 AM tomorrow. Thanks, everyone.